of the state of Michigan versus Melissa K. Moore, file number 25-22287FH. That matter was waived as well. So I have someone joining me from MDOC. Can I ask your name, please?
Sean Taylor.
All right. All right, I'm going to change your screen name. So Sean, S-E-A-N, right?
Yes.
Taylor, all right. And Miss Underwood, you are his attorney. So
Correct, Your Honor.
let's take care of him. All right, this is in the matter of Sean Taylor, the people of the state of Michigan versus Sean Taylor, file number 25-22271FH. This is a date and time set for a pre-trial in this matter. I have received an amended felony information. I have Rhonda Underwood appearing on behalf of Mr. Taylor and Isaac Sneed appearing on behalf of the people. Miss Underwood, how do you wish to proceed on behalf of Mr. Taylor today?
If I could just have one brief moment with Mr. Taylor, Your Honor.
Yep.
And I think
so, Mr. Taylor, I'm going to open up a breakout room and assign you and Miss Underwood to it. You should go automatically. So give me just a second. All right, join the breakout room. There he goes.
Hey, Sarah, I don't see the information on Van Meldigan.
Okay. Who are you talking to?
He's talking to me, I think. Or are you talking
No,
to
I'm
me?
talking to Sarah, my secretary. Sorry.
Oh.
Well, I'm going to call for Van Meldigan since you seem to be ready for him.
Well, that's the point, Judge. I don't see the information on it.
Hi, this is Judge Ansloan. I am ready for Jeffrey Van Meldigan.
Mr. Van Meldigan, you got it.
All right, thank you.
Yes, ma'am.
All right, I have the felony information in my file, Mr. Malaro, dated June 16th.
Okay.
Ma'am, are you here for a case or just to watch?
No, for court, I have a case. I have court at 8:30 for
What?
Noel Johnson.
What's your name?
Noel Johnson.
All right, you're Miss DeMont's client. So, sir, are you here for court today? What's your name?
Beagle.
Okay. Mr. Let's see, Miss Underwood, you're back. Let me close that breakout room. All right, Miss Underwood, we're back on the record with Mr. Taylor. How would you like to proceed today?
Your Honor, the prosecutor has offered my client a plea to an attempt, which is a 2.5-year felony, and which would be the amended count 2 of the guidelines and the dismissal of the habitual offender statute. We would also be asking the court for a COBS to the low end of the guidelines on this, Your Honor.
Hey, Mr. Sneed, is that a correct recitation of the plea and any position otherwise?
It is accurate, Judge, and I have no position. Thank you.
Okay, all right, that's fine, Miss Underwood. So, Mr. Taylor, you want to raise your right hand? All right, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, so they got you way across the room and I can barely hear you. So I'm going to ask you just to speak. Oh, there you go. You can move up a little bit and then just speak loudly for me, okay?
Okay.
Oh, perfect. Thank you. So, Mr. Taylor, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 attempted prisoner possessing weapon, which carries a maximum penalty of up to 2.5 years in prison and or a $500 fine? Count 1 would be dismissed, as well as your habitual offender third offense notice. So is it your intention to plead guilty to that?
Yes.
Now, do you understand, because you were an MDOC prisoner when this offense occurred, you do not receive any credit for time served? Do you understand that?
I do understand.
Yep, and this would be consecutive to whatever prison term you're serving now. Do you understand that?
Yes, I do.
Okay, good. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, I am.
Okay, other than the COBS agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Is that correct, Mr. Stein?
Yes, it is.
And Mr. Taylor, as far as you're aware, is that correct?
Yes.
Right. So, Mr. Taylor, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Taylor, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
All right. And do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you would not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. In your case, were you to commit a new offense while incarcerated and be charged, that means I wouldn't have to follow the COBS agreement to the low end of the guidelines. Do you understand that?
Yes.
Okay, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, sir?
No, I do not.
Okay, so how do you wish to plead to the charge that on or about March 27 of 2025 in Madison Township in the county of Lenawee, that you did commit the offense of attempted prisoner possessing weapons? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, they are not.
All right, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Okay, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood
No, Your Honor.
and Mr. Sneed?
No, Your Honor.
All right, so other than the agreement to sentence you to the low end of the guidelines, has your attorney promised you any particular sentence or estimate what your sentence will be other than that?
No.
All right, is it your own choice to plead guilty?
Yes, it is.
Okay, so Mr. Taylor, on March 27 of 2025, were you at the Gus Harrison facility?
Yes, I was.
Right, and were you incarcerated there serving a sentence?
Yes, I am. Yes, I was.
Okay, and would you agree, Gus Harrison is in Madison Township in the county of Lenawee?
Yes, I will.
Okay, and did you have in your possession an implement or something that could be used as a weapon to injure another person?
Yes, I,
Okay, and what was it?
excuse me,
What was it?
piece of metal, square in shape, similar to like brass knuckles.
Okay, all right, and you could have used those to injure somebody else, is that correct?
Yes, I could have.
Okay, Mr. Sneed, are you satisfied?
I am. Thank you, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood
It has, Your Honor.
and Mr. Sneed?
Yes, thank you.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Taylor, where are you currently serving your sentence at?
I'm still at Gus Harrison.
Okay, you're still at Gus Harrison. Okay. So someone from the Michigan Department of Corrections is going to meet with you to update your last pre-sentence report. Be truthful with them about your background, the events that occurred. They'll provide a copy of that report to us. We'll provide it to Ms. Underwood. She's really good about getting in and meet with people in advance, but sometimes MDOC is really busy and she can't. If she's not able to meet with you in advance, I'll give her time to do it that morning. And I'm going to set sentencing for August 8 at 8:15 in the morning. Mr. Taylor, do you want to appear via Zoom or in person?
Zoom.
Okay,
Is
so I
that
put down,
August 8th, Your Honor?
I'm sorry?
Is that August 8th?
Yes, August 8 at 8:15 via Zoom. So Mr. Taylor, we'll see you back on that day and good luck to you.
Thank you. You have a good day.
You too, thank you. All right, so I'm gonna close it out. Now I have someone else. It says MRF hearing, so I'm assuming that's MDOC. What is your name, please? I see a gentleman with the Michigan Department of Corrections. Can you hear me? Wave your hand if you can hear me. Okay, what is your name?
Foster.
Okay, is there anybody in there with you?
No.
Okay, all right, let me
Turn it
find
up.
you. All right,
Hear
it's
me?
kind of quiet. Yep, it's kind of quiet, so I'm gonna need you to speak loudly for me, okay?
Okay.
All right, so hold on one second. Mr. Glazier, where'd you go? Do you need a moment with Mr. Van Meldigan? In a breakout room?
I don't represent him, Mr. Van Mulligan.
Oh.
Judge
Who has-
Van
Mr.
Mulligan, Your Honor, Judge, hello, Judgey,
Yeah.
Judge. Van
Yeah.
Mulligan's mine, and I just got the information handed to me.
Do you want a breakout room with your client then?
Yeah, if we could do that, that'd be great.
Okay, go ahead and join the breakout room. All right, so this is in the matter of, I think you just called me Judgy. Did you call me Judgy?
Yes, you did.
Okay, so
No,
this is,
no.
I'm pretty sure you called me Hey Judgy. And I gotta admit, I'm judgy. I listen and I judge. That's what I do. All right. So this is in the matter of the people of the state of Michigan versus, so Mr. Foster, is it Leroy or Leroy? My husband's a Leroy. Are you a Leroy or a Leroy?
I'm a Leroy. They had to
Okay,
ask me was
so-
a nice report. My mother called me Leroy, but they called me Leroy in the Department of Correction.
Okay,
Jimmy,
can you tell them
Jimmy?
we're having a hard, can you tell them we're having a really hard time hearing you?
supposed to be trying to go. over this.
Mr. Van Meldigan, can you click join? Yep. There it goes. That's the only one you had, Miss Brenner, was Van Meldigan, right? Left? No?
No, Judge, I have Elliott and Hernandez.
Rodriguez or Hernandez Ramirez.
Yeah, Hernandez Ramirez.
Is Mr. Oscar Hernandez Ramirez here? It
Can you hear me now?
is. Say it again?
Can you hear me now?
It's real faint because you're so far back, but just speak up for me, okay?
Your Honor, I'm not familiar with the first name that you said that I have. It might be one that I have that I'm not aware of, but I don't.
Okay.
Huh?
Just try to talk loud,
All
okay?
right.
Mr. Foster can, okay. So this is in the matter of the people of the state of Michigan versus Leroy Deshaun Foster, file number 25-22267FH. I have Rhonda Underwood, correct, appearing on behalf of Mr. Foster. And I need a prosecutor. I need Isaac Sneed appearing on behalf of the people. This is the date and time scheduled for a first pretrial in this matter. Miss Underwood, how do you wish to proceed?
Your Honor, could I have a brief breakout with Mr. Foster?
Yep, and that reminds me, let me see here. Okay. All right, so Mr. Foster, I am going to put you in a breakout room with your attorney. You should go automatically. So there you go. Okay. She's gone. Mr. Glazier, I have Mr. Beagle. Would you like to take care of Mr. Beagle? You're muted, Mr. Glazier.
I can address Mr. Beagle in court. There's just a question I gotta ask him yet. It's
Ask
nothing.
me?
No, I just gotta tell him to come over to my office is all, Your Honor.
I'm sorry, Mr. Glazier.
Yeah,
I missed
I
that.
can proceed with Mr. Beagle, Your Honor. I'm ready.
Okay, this, Mr. Beagle, you want to come up to the podium? We move the microphone way down. Or do you want to have, he can have a seat with the microphone if he wants to. Do you want to stand or have a seat, Mr. Beagle? Am I here? Okay. So this is in the matter of the people of the state of Michigan versus Jeremiah Richard Beagle, file number 25-22187FH. I have John Glazier appearing on behalf of Mr. Beagle, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference. Mr. Glazier, how would you like to proceed?
Your Honor, we had asked for a forensic on this case, and we've got a date. I've got the directions and the date for Mr. Beagle. We've mailed them to him. They've come back. So, Mr. Beagle, I'd like to meet with you today at 10 o'clock. Is that possible?
What time is it?
Today at 10 o'clock, you need to go to Mr. Glazier's office. Do you know where that is?
Yeah.
All right, so they've got the date and time set up for your forensic exam. Are you gonna be able to get there? Okay, so go to see Mr. Glazier today at 10 o'clock.
Okay.
All right, Mr. Glazier, in light of that, I'm gonna set another date, and Ms. Adams, I'm gonna need a notice of hearing for Mr. Beagle. So, Mr. Glazier, September 10th at 8:30.
Did you say 9:30?
8:30.
8:30. Okay.
Okay, and Miss Adams, if I could get a notice of hearing from Mr. Beagle So we're gonna give you your notice of hearing for our next court date. And then at 10 o'clock, in about an hour, you need to go to Mr. Glazer's office, okay? All right, so have a seat right behind you and we'll get you the paperwork.
I'll see you. I'll
Thank
see you
you.
at 10, Jeremiah. I'll see you at 10 o'clock.
Like, thank you.
All right,
That's all I have with you this morning. Thank you, Your Honor.
thank you. Okay. Okay, all right, Mr. Malaro and Miss Underwood, let me do, you want these files? Okay. Oops. All right, so Miss Underwood, real quick, in the matter of, let's start with, Jeffrey Elliott here. Okay,
Honor?
in the matter,
Your Honor,
Yeah.
Mr. Elliott is in our reception area. If you're ready, whenever you're ready, I'll bring him back.
it's my understanding Miss Brenner has two cases with you and Miss Underwood, and they're both being adjourned today.
Well, Mr.
So-
Elliott has also a drug charge as well that's up for pretrial.
Yep, Mr. Hertung's here on that, so I was just trying to get Miss Brenner on her way to the next court she needs to be in, so. In the
I can
matter
bring
of
him
the
back.
people of-
I'll go get him.
Okay, so in the matter of the people of the state of Michigan versus Oscar Hernandez Ramirez, file number 24-21965FH. I have Rhonda Underwood appearing on behalf of Oscar Hernandez Ramirez and Sarah Brenner appearing on behalf of the people. I've got somebody on a phone, but I haven't seen him in person. I just let somebody into the Zoom room on a telephone. Can I ask your name, please?
Oscar Hernandez.
Good. All right, so Miss Underwood and Miss Brenner, how far out are you asking to adjourn this matter?
Your Honor, I would say close to 90 days. Mr. Hernandez Ramirez is making regular payments, Your Honor. So I really think 90 days, we'll see where we are.
Miss Brenner, any objection? Miss Brenner, we didn't pick up audio. Do you object to September 17 at 8:30? Oh, we have no audio for you. Okay, but I can read lips. So we will adjourn this to September 17 at 8:30 in the morning. Miss Underwood, you can do the stip in order to
I would be
adjourn,
more than
and
happy to.
Miss Brenner, do you have any objection to adjourning to that day?
No objection. Can you hear me now?
Yeah,
Okay.
I can hear you now.
Computer.
So,
microphone
Mr.
goes
Hernandez Ramirez, we're going to adjourn your court date to September 17 at 8:30 in the morning. And it's the same Zoom number, okay?
September what?
17 at 8:30.
17. Okay. All right.
Okay, very good. And keep up the good work. You're making payments, so that's great. Thank you.
Okay.
Thank you.
Bye-bye.
Thank you, Judge.
Bye-bye. Thank you. All right, so in the matter of the people of the state of Michigan versus Jeffrey Allen Elliott, we have four files, 21-20212FH, 23-21200FH, 25-22203FH, and 25-22204FH. I have Salvatore Millar on all the files, and I have Sarah Brenner on 23-21200FH and 25-22204FH. And then I assume it's Douglas Hartung on the remaining two. He is not here. but it's my understanding that he is consistently making payments on his child support case. Is that correct, Ms. Brenner?
Your Honor, he's in Mr. Malero's office. But
Oh,
yes.
that's right. I forgot. Sorry, Mr. Elliott. All right, so,
But yes, he's paying consistently through an income withholding, and he is making good efforts at his payments, Judge.
so Mr. Malaro, how would you like to proceed today?
Can you hear me?
No,
How about now? Can you hear me now?
we are not in front of your microphone because your computer's facing him. Oh, there you are.
Can you hear me now, Judge?
Yes.
Judge, I'd ask to adjourn these cases for about 60 days to see about resolving the drug charge and the child support matter.
That's
All
fine,
right.
Judge. No objection.
Mr.
objection.
Hartine?
No objection.
Okay, so 60 days, let's see, that would be, how about August 27 at 8:30?
That's fine, Your Honor.
That's fine, Your Honor.
Okay.
Thank you.
All right, so, Mr. Malaro, though, you get to do the step in order to adjourn on all the files. And Ms. Brenner, can you sign your name with permission?
Yes, thank you.
And Mr. Hartung?
Yes, absolutely.
All right, thank you.
Thank you,
Thank you, Your
Judge.
Honor.
Thank you. All right, Mr. Foster. So we're back on the record with matter of the people of the state of Michigan versus Leroy Foster. So Ms. Underwood, have you had a chance to speak with your client?
Yes, Your Honor. Thank you.
And how would you like to proceed today on behalf of your client?
Your Honor, Mr. Foster is at Macomb, and the communicating with Mr. Foster is a little difficult under these circumstances. And I discussed with Mr. Foster being brought down for the next pretrial, so we don't have these issues. So I would very much request a pretrial and a in-person writ for Mr. Foster.
My next available is July 23rd at 8:30 in the morning. So we'll need that writ for transport, Mr. Sneen. I think your office does those. And you can do the step in order to adjourn, Miss Underwood.
I would be
And
more than happy to.
okay, Mr. Sneed, is that all right?
Same. Mr.
Okay.
Foster? Yeah, it's all right.
So, Mr. Foster, we're gonna have you brought in person for the next date, okay?
All right,
All right, thank you, Mr. Foster. You have a good day.
thank you. All right,
Thank
Ms.
you.
Underwood.
Okay, so Mr. Malaro, Mr. Van Meldigan?
Yes, ma'am.
All right, so in the matter of the people of the state of Michigan versus Jeffrey John Van Meldigan, file number 25-22286FH. This is the date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the felony information?
Your Honor, at this time, we would acknowledge receipt of the information, waive its reading in open court, waive any defects in the time and place of service. Mr. Van Meldigan will stand mute as to count one of the information and the habitual offender fourth notice. We further acknowledge receipt of the witness list. Mr. Van Meldigan would stand mute, ask court to enter a not guilty plea and set this matter for pretrial.
All right, July 23rd at 8:30 in the morning, Mr. Malaro?
Judge, I
Are you
will not
gone
be
that week?
available on that date.
All right, August 6th.
That would be fine.
All right, so Mr. Van Meldigan will set this for pretrial on August 6th at 8:30 in the morning. We'll do the pretrial notice because it is an arraignment. And we will see you back on that day. All right, Mr. Van Meldigan?
Yes, Your Honor. Thank you.
All right, thank you.
Your Honor, do you have Mr. Nine in your waiting room or in the courtroom?
He's not in my, yes, I have him in my waiting room. Okay. All right, Adam 9, if you can start your audio and your video. All right, this is in the matter of the people of the state of Michigan versus Adam Matthew 9, file number 24-22018. I am Rhonda Underwood appearing on behalf of Mr. 9, and I need a prosecutor. Anybody? Anybody? Mr. Hartung? Mr. Stein?
I can step in. I don't know anything about it, but I can step in for the hearing if you'd like me to.
I don't know. Mr. Stein probably had to step away. So, Ms. Underwood, how would you like to proceed today?
Your Honor, we have the diversion amount worked out. Mr. 9 has an appointment with Mr. Wendt next week to bring in his proof of payments and sign the agreement. We don't anticipate any problem. So we probably just need a pretrial date out about 60 days.
All right. August 27 at 8:30 in the morning. I will set a pretrial, August 27 at 8:30 in the morning. And Ms. Underwood, can you do the step in order to adjourn? And Mr. Hartung, can you sign your name with permission?
Yes, and what is this defendant's name one more time, please?
Adam 9.
N-I-N-E.
Okay.
9, like the number, yep.
Gotcha. Thank you.
All right, so thank you, Mr. 9. Make those payments and we'll see you back August
You still there?
27 at 8:30 to see how it's going, all right?
Thank you, Your Honor.
All right, thank you, Mr. 9.
29.
Let's see. Ms. Underwood, I think that's all I have with you, right?
Well, I have a couple of, they say VOPs, Kayla Walden.
I have
and
Lyens.
Lyens.
Okay, so he's not here. Is he here? No. In the matter of the people of the state of Michigan versus Benjamin Lee Lyens, file number 23-21610 FH, 23-21611 FH, and 24-21736 FH. This is the date and time set for probation violation show cause. A show cause notice was mailed out for him to appear today. He has failed to do so. So, hold on a second. What is that? He has failed to appear. Let me see something. So, oops. I guess he must have. What is the date of the show cause for this one? Let me see here. First it's 97. Mr. Lee, Mr. Lyens, is he in absconder status from recovery court or is?
Yeah.
Okay. Yes?
I believe so.
Okay.
He hasn't been, he's been missing and he hasn't been drafted.
Okay, great. Thank you.
You're welcome. Okay.
All right, so Ms. Underwood, he is not here. He is not in compliance with recovery court. So I'm going to issue a bench warrant for his arrest and I'm going to set bond on each file for $25,000 cash surety.
Thank you, Your Honor. And what about Ms. Walden?
Well, Ms. Walden, isn't that the one you strong-armed me into releasing, right? So let me call Darren Coast. Because I think she might be. Okay. She's not here.
I don't think so, Judge, but I'm not sure. All right.
Let me see. Hold on, Ms. Underwood, and let me verify some information. Because he may not be here, but I know his cell phone number. All right, so hold off on that. Give me 2 seconds. I know we did an order. She must enter Dawn Farms and complete and then report to the probation department. So let me see if she's still, let's verify if she's still there yet or not. So I've sent a message to Mr. Coast. Miss Underwood, if you want to go ahead and take care of your other stuff, we can circle back on Miss Walden later, all right?
Thank you so much, Your Honor.
All right, thank you. Okay, so Joshua Park. Mr. Malaro and Mr. Murphy, so.
Good morning, Your Honor.
Good morning. I am ready for Joshua Burke.
Mr. Burke, you got it?
Thank you.
Of course.
So it's nice. Richard Garza, Mr. Murphy, I have Mr. Garza. Mr. Garza, you can come to the podium, or is that all right? All right. Okay, this is in the matter of Richard Perry Garza, file number 25-22250FH. I have Isaac Sneed appearing on behalf of the people, and I have Matt Murphy appearing on behalf of Mr. Garza. This is the date and time set for a, looks like a pretrial conference. Miss Adams, or hold on. Mr. Murphy, how do you wish to proceed today?
Your Honor, can I talk to Mr. Garza? Can you go out in the hallway maybe?
All right, so Mr. Garza, your attorney would like to talk to you. So my bailiff's gonna take you in the hall.
Okay.
We have a device there, okay?
All right.
Okay, who, are you guys here to watch or anybody have a case? Miss Adams, I also don't have Mr. Raines, so I don't know. What are you hearing?
I'm covering for Mr. Sneed. I'm sorry, I got stuff next door.
Okay, but Mr. Sneed's here.
Oh, he's here.
Okay. All right, so I am going to open up a breakout room with the circuit court hallway. Mr. Murphy. Can you unmute it and start the video? I don't think they know how to do it. And I sent an invite. Join a breakout room. He's not only a bailiff, he's IT too. So.
Mr. Rain's office yesterday did let me know that he had another hearing and would be here as soon as possible.
Okay, thank you.
Yeah.
Charity Smith. Mr. Malaro, you ready on Charity Smith? Your attorney's here. Yep, she's on Zoom,
Yes.
but I go by the attorneys that have been here the longest.
Okay.
And she's here and she'll be next.
Okay, thank you.
All right, Charity Smith, go ahead and start your audio and your video, please. All right, thank you. This is in the matter of the people of the state of Michigan versus Charity Christine Smith, file number 24-22056FH. I have Salvatore Malaro appearing on behalf of Ms. Smith, and he popped up, so I'm assuming Alexander Bayonetto appearing on behalf of the people.
Yes, Your Honor.
So, Mr. Malaro, how would you like to proceed with Charity Smith?
Your Honor, what I'd like to do is adjourn this past into August. The reason being, Ms. Smith is slated to complete her requirements at Jackson College. And then I think this matter would be ripe for resolution.
Any objection to that?
No, Your Honor.
All right, so I will adjourn this to August 27 at 8:30 in the morning, and Mr. Malaro, you can do the stip in order to adjourn, and Mr. Banetto, can you sign your name with permission?
Okay, thank you.
All right, thank you very much. All right, Mr. Garza, why don't you
Thank you,
come back
Judge.
up to the, and I think, Mr. Malaro, that's all I had with you, right?
If you say so, Your Honor, you're the boss.
Yes, you're good. I'm the judgy, so you're good, Mr. Malaro.
I
You
did
can go
not
the
say
next
you're
one.
judgy.
You said
I didn't say
judgy.
that.
You said judgy.
No.
All right, you called me judgy.
I did,
So,
no.
it's okay. I've been called worse.
Have a good day, Your
All right.
Honor.
You too, thank you. All right, so we're back on the record with Mr. Garza. Mr. Murphy, how would you like to proceed with Mr. Garza?
Your Honor, I think we're going to ask for another pretrial on this matter. I don't think we need a lot of time. So whatever is the next pretrial available, that's not too burdensome for the court schedule. At this point, I think that's better than setting a trial on this matter. I think there's still some negotiation that could be had, unless Mr. Baynett.
Okay, so I'm going to set this to July 23rd. Ms. Adams, could I get a notice of hearing from Mr. Garza? So July 23rd at 8:30 in the morning. So Mr. Garza, I have a seat right behind you, and my assistant will get you a notice of hearing, all right? She's doing that now. Okay, so Mr. Murphy, let's see what else we have with you.
Mr. Olmsted.
Yep, he is in the waiting room. And then we'll switch over to Mr. Mott. Unless you're like, gonna go,
No, I just got to the word 11, that's all.
oh, you'll be done next.
Yeah. Yeah.
All right, Mr. Olmsted, can you start your video? All right, this is in the matter.
You said. Okay. No, I got it. I need to see your list, because I didn't address.
This one was withdrawn. H was withdrawn. And B was not admitted.
Got it, but then,
And then I have C through F.
okay, right, and those are the ones I'm more worried about, because on the people's side, you only have what, one?
Just A, just one, yeah.
Okay, and I just want to make sure we get it clear on the record about that. Court calls case, People State of Michigan versus Jillian Kerry.
Ashley Lundy for the people.
Good evening, Your Honor. Michael Bellotta on behalf of Jillian Kerry, who's present in court.
All right, your name, ma'am?
Julie Kerry.
All right, thank you. All right, just some housekeeping things here, counsel. I have a note that at the last hearing, you had submitted to the court exhibit C through F. But I don't know that I don't have notes of testimony regarding those. And C through F were not addressed at all.
Yes, Your Honor, that's true. The only exhibits that were admitted, we just confirmed with Ann, are exhibits, defense exhibits A and G.
Yes.
Those can be returned. I'm not going to be going.
You will not be
I
using.
don't think I'm.
Okay, all right, that's fine. I just wanted to make sure.
As well as People's One. Those are the exhibits that have been admitted at this.
Correct. I didn't have a problem with any of People's exhibits, so we can hand those back. I didn't have a problem because I only had one. I had note that was admitted. I had the admitted, no, those go to defense. And I had defense exhibit A was admitted, B was not, G was admitted, and I think H was withdrawn. I just did not have anything regarding those exhibits, and I just wanted to make sure the record's clear.
B wasn't.
Pardon?
No, he was not.
Not admitted. No,
He was not.
but not, that's what I thought.
Okay. All right, I think that's what I said, so I think we have it. All right. We ready to continue, folks?
The people are ready.
All right, we call you next witness.
Alex Phillips, Your Honor.
All right, sir, please come forward and be sworn.
Before you take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God? I do. State, spell your first and last name for the record.
Alex, A-L-E-X, Phillips, P-H-I-L-L-I-E-S.
You may.
Thank you, Your Honor. Sir, how are you employed? In what capacity? How long have you been in that position?
Approximately 5 years.
Were you so employed on or about November the 20th of 2023?
Yes.
Did you go to the Scioto Township office on that date?
I did.
For what purpose? And when you went to Scioto Township on the 20th, what were you going there to do on that date?
On the 20th, I believe, was to retrieve the laptop, reference the initial complaint.
Did you retrieve it? Where did you take it?
Back to Station 7,
For what purpose?
for safekeeping until detective forensic, check it.
Not your department, correct? Okay. May I have one moment, Your Honor?
Yes.
You log in into a secure location at Station 7 when you ticket in?
I do not recall.
Okay, thank you. I'll pass the witness.
All right, cross-examine.
Thank you, Your Honor, just briefly.
Good evening, Deputy Phillips. Now, are you the officer in charge in this matter?
Yes.
And on November the 16th, were you working on duty that day? And before I question any further, Your Honor, I'm going to go beyond the scope of that. Should I?
Hey, everybody, I'm just going to jump in real quick and kind of give a heads up of what's going on with this case. So you've got a lady that's running for a local political office, and she's being accused of sending emails to herself from someone else's computer. Apparently, it's a shared computer, but they're accusing her of that, and that, you know, turns out looking something like theft, looking like corruption, looking like a little bit of everything. I completely destroyed it. I completely messed it up. I completely twisted the evidence on it, but that's why this court, y'all watch it and have fun.
I'll let you go.
But I'm going to be brief, but I know that I'm going to ask questions that are not.
As long as it's relevant.
Okay, thank you.
Go
Thank
ahead.
you. I just wanted to let you know that. Thank you. And so you took the initial report that evening from Mr. Will Hathaway, is that correct?
Yes.
And he told you that, I mean, the complaint was just generally that his email had been breached. I think you said in your report. Is that right?
Yeah, I do think that is hearsay. I reject.
I'm just establishing.
Regarding Hathaway's statement,
Yes.
I'm going to sustain that.
All right. Well, I'll move past that then, Judge, and I'll go to.
Hang on a second. Restate your question again.
I was asking him what was the general allegations, the nature of the complaint.
No, I'm going to change my mind on that. I'm going to let that be answered as long as and we'll only be taking the responses to go to this officer's state of mind and what he may have done.
Thank you, Your Honor.
All right.
Yeah, thank you, Your Honor. And so the general allegation, wasn't it, that and I think Mr. Hathaway let you know that his email had been breached. In other words, somebody accessed his email and sent an email to another official at Scioto Township. Is that right? Okay. And then on November 18th, according to your report, you spoke with Detective Parvis. Is that correct?
Yes.
And you gave him a short summary of the allegations. Is that right?
Yes.
And based on this short summary that you gave, Detective Parvis told you that criminal actions had been taken. That's according to your report. Is that right?
Your Honor, objection, hearsay.
Oh, I'll overrule it.
Thank you, Your Honor.
And when he made that statement to you, you put that in your report, correct?
Yes.
But that was on November the 18th, correct?
I believe so.
And that was 2 days before you just testified that you went and retrieved the laptop that's at issue in this case. Is that right?
Yes, sir, that sounds right.
Okay, so did you think his declaration, well, I'll withdraw that question. The warrant was issued for my client on June the 13th of 2024, is that right?
Believe so.
But without tying you to a particular date, was it around June of last year that the warrant issued?
That sounds right.
Okay, but you didn't swear to it, is that right? And Officer Howard Schaefer did, is that true?
Yes, sir.
Did you provide all of the relevant evidence and information to Deputy Schaefer prior to his swearing to this?
I'm not entirely sure how he reviews the reports, but he reads the report that's submitted and swears to it, is my understanding.
Okay, and before you sought the warrant, did you do any investigation yourself?
I interviewed people.
Did you interview Ian Hubert?
I did.
Did you write a report on that? Or did you like a separate report for Ian Hubert's interview?
It was in one of the supplemental reports, yes.
All right, so it would be like a paragraph or two in the report, but not a separate report, is that right? Do you know when you did, when you interviewed him? If it isn't in the report?
I believe it was in the report, but off the top of my head, I don't know the exact date.
Would it refresh your memory to look at your report?
It would.
Can I approach?
You may.
Look at that and let me know if that refreshes your memory, please. And if that's not the right report, please let me know that too. Did that refresh your memory?
Yes.
And do you recall now when you interviewed Mr. Hubert?
I believe it was the next day.
When you say the next day, would that be the November the 17th?
Yes, sir, I believe so.
Okay, so when you say the next day, so the next day, the day following the day that he came in and made the complaint, correct? And did you also interview Mr. Will Hathaway?
Yes, sir, I did.
And did you also interview Jillian Kerry?
Yes, sir.
Did you interview Jessica Flintoff, the individual who is alleged to have received the forwarded email in question? If you didn't interview, what's the reason why you didn't? Were you actually in charge of the investigation, or at some point did you turn it over to Detective Parvis? Okay, just because I don't understand it, would you consider Detective Parvis then the investigator in charge of the case, or are you both investigators in charge, or is there no designation? I don't know.
I'm listed as the officer in charge, but I think Detective Parvis and
All right, just so that I don't waste the court's time, especially at this late hour, I'm not going to ask you any questions. Then, if you don't know, you don't know anything about Microsoft Purview audit logs or anything like that that go to the heart of the issue in this case on the computer side of it. You don't know about that stuff, correct?
Correct.
All right. Did you interview Francis Zuma, the recipient of the calendar invitation in this case? And again, is there a reason that you didn't, or did you, was the duty at some point to interview witnesses, was it turned over to Detective Parvis?
Joint venture.
Okay, but do you know why she wasn't interviewed, if she wasn't?
I don't know.
And if I could approach Your Honor with Exhibit G admitted, can I approach Your Honor?
Yeah.
Do you recognize Defense Exhibit G? Have you ever seen that document?
I don't believe so.
Okay. Did you, during the course of the investigation, did you speak with one of Ms. Kerry's attorneys named Mark Chutko?
I believe I spoke to an attorney, I'm not sure though.
Okay. Did Mr. Chutko provide you a copy of Exhibit G, if you recall?
I don't know.
You don't recall? Okay. And do you see what's highlighted on that page? Could you just read that?
Direction on exhibit speaks for itself.
I want to ask him about it. What
Well,
it
did you
says.
see the highlighted, the part that starts with sorry?
Well, he said
Yeah, I
he
just
read it
I
as
wanted to
well.
read it so I can ask a question about it.
Well, we'll read it, not out loud, just.
All right, read it to yourself if you
Go
will.
ahead, and then you can ask questions.
Okay. Okay, so it's an email. You see there's an email to someone named Kim Moore, amongst other people, by looks like Mr. Will Hathaway. Do you see that?
Yes.
And do you see that the email says, sorry, this email seems to have sent itself again when I logged in just now? Do you see that?
Yes.
Okay, would that have been an important piece of evidence for your investigation if you're trying to find out whether or not the email in question was sent by Mr. Hathaway or whether it was sent by Ms. Kerry? Would that have been an important piece of evidence, do you think?
Tanner, I'm sorry.
Well, I'll rephrase the question. It was a poor
Thank
question.
you. That was.
Yeah, I'm sorry. If you had seen this as you read it, as you heard me read it now, and you read it to yourself, would that have been something that you would have put aside or said that this is important to the case?
Yes.
And do you recall doing that? So then do you think you didn't receive this or do you not recall?
I don't believe I received it.
Okay. All right, thank you. I'll grab that back. And you didn't interview Kim Moore, the woman on this email, did you?
No.
Did you investigate the relationship between Jillian Kerry and Mr. Hathaway to see if there's any acrimony between the two of them or any motive by either one of them to either send an email or say that someone sent an email? Did you look into the relationship, I guess, in your investigation?
I was informed of some tension.
Okay, but did you interview anyone based on what you were informed or no?
I don't believe I interviewed anyone specifically about issues they have. I believe it was brought up during the course of speaking to people.
Okay, and then on November 19th, the day before you went and you got the computer, did you interview Jillian Kerry at her home? And did you give her any notice that you were going to come out and interview her?
I don't believe so.
Okay, and you did that at night, right? Is that right?
Yes, sir. Afternoon.
Okay, and did you go by yourself?
I believe so.
Was there a reason that you went at nighttime without giving her any notification? Did you consider maybe calling her and letting her know you were coming?
I generally just go knock on people's doors first if I can, and I work at the time I worked 4 to midnight roughly.
So it was really based on your shift is why you went later in the day as opposed to some trying to gain some kind of tactical advantage. Is that right? And she agreed to speak with you, did she not? And she invited you into her home? Was she cooperative? And did she agree to answer questions about what happened? She did? And did she, and isn't it true that she didn't admit to doing anything illegal? Is that correct?
This time is the hearsay.
Sustain.
All right, in your report, I noticed that you updated your report on occasion. Is that fair to say?
Yes, sir.
And one of the updates in your report, you write, William requested to have Detective Parvis look through the computer. And I can show you a report again if you don't recall that. It's on page 5 of your report. Would you like to see that again?
No, I remember.
All right, so was it the fact that William Hathaway requested that Detective Parvis look at the computer? Is that what caused you to go get the computer?
I believe I was coordinating with Detective Parvis, trying to examine the computer to see if that would be beneficial for evidence.
Okay, but you weren't doing it just because William Hathaway asked for it. That was Detective Parvis who said you need to get the computer. Is that right? Now, I understand that you took what we call the shared laptop. We're going to call it the shared laptop, the shared SIO laptop. You took that to get to Detective Parvis to examine forensically, correct?
Yes.
And did you ever take William Hathaway's cell phone? It was never imaged as far as you know, correct? It was never extracted, I guess is the right word. Okay. And did you try to determine what other devices that Mr. Hathaway was using at the time this email incident occurred?
I don't know.
So you don't know if he was using an Apple computer, for instance, an Apple laptop? You don't know? And Detective Parvis never had you go get any other devices besides the shared laptop, correct? Is there any reason why you didn't image the other devices if the issue had to do with who sent the email?
Any reason he didn't what?
Any reason that he didn't get any other devices to see what the activity was on Mr. Hathaway's devices?
After speaking to Detective Parvis, he recommended the laptop. Move it out of my wheelhouse.
You were kind of letting Detective Parvis make the calls on what he needed forensically, correct?
Yes, sir.
And do you remember on February 9th of 2024, Mr. Chetko providing you a copy of Exhibit G? I was just wondering if the date would help you. Do you remember getting something from Mr. Chetko in February of 2024?
I do not.
Okay. And are you aware of Mr. Chetko sending you a copy of a report done by a company called N1 Discovery? And my last couple questions have to do with this. You were aware at the time that you were investigating this initially, and I'm talking about in November of 2023. You were aware at that time that William Hathaway was the supervisor of Scioto Township, is that right?
Yes.
And the fact that he was the supervisor of Scioto Township, did that have any effect, either positive or negative, on the way you handled your investigation?
Yes, I would so.
Okay, can you explain that?
Given that it's a high profile nature, generally it's better to inform people of supervisors and so forth.
So as far as notifications, you were more careful with that because of the complainant's position?
Yes.
Anything else that you did differently? So there was no special treatment given to Mr. Hathaway, certainly, was there?
I don't believe so. No.
Thank you. I have no further questions.
Any redirect?
Yes, Your Honor. Deputy, do you still have a defendant's exhibit G with you?
Sorry.
Okay, great. I'm just actually, if I can use the system, I may prefer that. May I, Your Honor?
Yes.
Thank you. Deputy, you testified earlier that the date that you initially went to this call and sort of worked on this was in what month of what year?
2023.
And this should be live now. This is defendant's exhibit G that's previously been admitted into evidence. You were asked questions about a few moments ago. Do you recognize this?
Yes.
What's the date on this email?
1/31/2024.
So when your investigation was happening initially in fall of 2023, that email hadn't even been sent yet? Thank you.
Oh, thank you. You may step down. Thank you, sir.
Is this the excuse, Your Honor?
No objection.
All right, this witness is excused. Thank you, sir.
Thank you, Your Honor.
May call your next witness.
Kevin Parvis.
Sir, please come forward to be sworn.
C, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, so you got it. States for your first and last name for the record.
Detective Kevin Parviz, last name spells Parviz.
Thank you.
Inquire.
Sir, how are you employed? And how long have you been in that position? Do you have any other prior police experience?
Yes, I was a Detroit, Walden, and,
What role or position do you currently have within the sheriff's department?
I'm in charge of our computer forensics lab.
And what does that entail?
Forensically examine cell phones, computers, digital media in general, and pretty much anything that is computer related.
Do you complete extractions and forensic downloads of different devices as a component of that? And do you, or had you previously worked with Homeland Security as well?
Yes, I worked with them for as a task force officer for nearly 10 years.
What is your educational background?
I have a bachelor's degree in insurance, network security, specification, and master's degree in computer forensics, and a PhD in information assurance with my dissertation specifically in computer forensics. I also did some postdoc research with Science University.
Do you currently teach? Have you taught in the past?
Yes, I taught for
Where at?
both at Eastern Michigan University, both graduate and undergraduate classes, and at Washington Community College.
What types of classes would you teach at those facilities?
Anything from incident response, network security to computer forensics levels 2 and 3, the highest one is 3.
What special training do you have related to computer forensics?
I have more than 70
You stopped counting? Do you recall when your most recent trainings may have been?
Most recent one was actually last week. Was celebrate certified operator, CPLA certified operator.
Cellbrite is a tool to extract cell phones. Your Honor, may I approach actually to give to the court a copy of People's Proposed Exhibit 2?
You may.
And your current title, sir, is that a detective corporal, is that right?
Detective.
And how long have you been a detective corporal?
Since March of 2003.
March of 2003. So you've been a detective since 2003? And Your Honor, permission to put People's Proposed Exhibit 2 up on the screen? Have you recently completed or updated your curriculum vitae?
I did. I don't think it reflects my last week's training.
Not last week's training, but up recently. Does this appear to be a fair and accurate copy of your CV? 8 pages?
I believe so.
Your Honor, I move for the admission of People's Proposed Exhibit 2.
Any objection or order?
No, Your Honor.
She was admitted.
Sir, have you previously been qualified as an expert witness?
Yes, several times.
In what fields?
In computer forensics.
How many times have you testified as an expert in computer forensics?
Many times. I don't think this is-
Have you been qualified as an expert before judges within Washtenaw County? Your Honor, I move to qualify this witness as an expert in the field of computer forensics.
No objection.
Qualified.
Thank you. Detective Parvis, how did you initially become involved in this case?
Deputy Phillips, thought that some cases has come up.
And what is your general process when you're going to become involved in a case and do any computer forensic investigation?
I basically start collecting evidence through the officer in charge of the case. In this case, the Deputy Phillips. I asked him to, my role is an assistant to the local patrol, that I can't go and collect and do the computer forensic huge backlog that we have at the moment.
What, if anything, did you advise Deputy Phillips to do in this case, reference the computer at issue?
So initially, I needed to get the, I believe it was the header, email header information which he provided, and then I needed to get the server logs. That's usually the first thing I do. And I believe at some point, 2 years ago, about, so I believe that he told me that it was getting too technical, so I kind of stepped in and contacted the Scioto Township IT.
At some point, did you actually get your hands on the laptop at issue in this case, what's been called the Scioto Township shared laptop?
Yes.
Were you able to image that laptop? What does that mean?
It's basically, when it comes to computers, it's a bit by bit where the image that the last item, digital item on the storage portion of the laptop. It's going to be transferred to a forensic machine.
And did you complete, I'm going to start with, did you complete a report and date it December 14th, 2023 related to this case? And is that report contain your expert conclusion and analysis? Your Honor, I have for the court, People's Proposed Exhibit 3, which I move to admit at this time.
Your Honor, I'm going to object. This witness's report is hearsay. It's not admissible. He's on the stand to testify about the contents of the report. I've never seen anyone introduce the actual report as evidence. I don't understand the basis for this. So hearsay is my objection. Thank you.
Your Honor, he is an expert witness and he has come to these conclusions. These are his expert conclusions, excuse me, and the report that he prepared for this case after analyzing the evidence. I do believe he is allowed to have this. I do believe this is a proper thing to be admitted for the court to consider.
It's statements of this witness. The witness is on the stand. He could say what his report concluded.
But if you have an expert witness and they produce a report, could have a number of different types of expert witnesses. Why wouldn't they be allowed to submit their report?
Just reads like a police report, Your Honor. He talks about who he questioned, what they said.
No, but your objection isn't that it reads like a police report.
It's hearsay. Thank you.
Well, right, but your objection is that the report itself shouldn't come in.
Yes. If there's something particular in the report that's not being offered for the truth, I would have no objection. But there's lots of stuff in here that's statements of fact.
As an expert, though, he's permitted to give his opinions, his conclusions. That's what's different about this report. And as you compared it to a police report, that's one of the distinctions. I mean, experts are allowed to do certain things. They're allowed to deal with hypotheticals. They're allowed to, experts can do different things. So is your only objection to that report that it's hearsay?
That's my objection.
All right.
Most of this is hearsay. Thank you.
I'm going to admit Exhibit 3.
Your Honor, may I approach the witness and the court with copies?
Yes.
Thank
Sorry,
you.
you overruled it, Your Honor. I didn't hear your ruling. You overruled it, correct?
Your objection?
Overruled, right?
Yes.
Yes, thank you.
On that basis.
Okay. So starting on Exhibit 3, page 1 appears to be a cover page, correct?
That's correct.
And starting on page 2, there's a highlighted portion. What was significant to you about the bottom of page 2 where you wanted to highlight this piece of information?
It is showing the email that was sent out. And it is using an IP address.
What's an IP address?
An IP address is basically like it's the translation, the technical version, or you want the.
You, sir, I trust your explanation, so you can give us both if you prefer to make it a little more hands-on.
So when a computer needs to internet, actually provide credentials to the internet, then internet will assign it a number, and that is the IP address, like a house address.
And you were able to determine what about this IP address, if anything, or why was it highlighted for you?
Yes, it's that is the Wi-Fi Wi-Fi IP address of Scioto Township.
Okay, thank you. And so knowing that this is the Wi-Fi address of Scioto Township, moving on in your report, and page 3, I see a section called message trace. Can you explain what the message trace is, please?
Message trace is basically a function within a server that an email server that you can command it to retrieve information, really detailed information about an email that was sent or received, a journal. Whatever happens to an email is going to be.
And you mentioned something about an email server. Is there a distinction between an email server and what's on a computer about an email?
Yes, an email server. So when emails came about, they were using what was called POP. That was the Post Office Protocol version 3, POP 3. And with that, you had let's say a laptop. When I communicated with somebody, whatever I sent and whatever I received remain on that computer. The problem was with, if I'm at home and I leave the laptop behind, all my emails are going to remain on that laptop. So they came up with a newer protocol, and with that, it's called IMAP. And what it does is that the computer becomes the brain of the operation. Your laptop will give you an illusion that you're actually commanding something, but all your commands are going to the server. And I'm sure we've experienced when we had internet, but then we were trying to send an email, and if the server is busy, you're going to get a little circle, and if you click again on your application, on your mail application, it's going to turn into like a ghostly looking thing. That's because the server, you are at the mercy of the server.
And when you perform a message trace, are you looking at server data, computer data, both? What are you doing?
It's basically both and then some. It also shows the nodes that it had traveled through. The header information provides some information, but the server log is the mail server log has much more extensive.
When you started doing the message trace on the email at issue here, the one that was sent to Will Hathaway on the evening in question, what did you find?
I found out that if I could take a look.
Yes, it's in evidence now, so you are absolutely allowed to refer to People's Exhibit 3.
So
page 3, I think, is where we're at right now.
I see that there was. I saw that there was a lot of communications. There was a log of transactions starting at or about 6:08. I'm sorry.
If you have a different place you'd like us to look at the information.
So this is UTC time, London time. It's going to be $2,200.06.
And that's in the back of the report where we have this sort of just raw data, I'll call it, page 7 of 8, towards the end of this report.
This is a because of the issues that we have with our reports community, a lot of excess.
Okay. So the sheet that we're looking at now, it should say at the very, very top, 2023-11-15T 220450 journal at Scioto Township. Okay. On this page, please
Sorry, I'm
combine.
not following, tracking this. I have the page 8 of 8. Is that what you're looking at?
Nope, page 7 of it.
7.
Oh,
7 of
sorry.
8. Yep.
At the top?
Yep. I just wanted to make sure we're all on the same page. So please go, please, Detective.
Hold on.
Yeah.
7 of 8.
Yep. So at the, it's this attachment is 8 pages. So it is 7 of 8 towards the back, Your Honor. I
No,
believe
I
is,
see that.
yeah.
And then you say at the top it says what? Because mine,
Can't find 7 of 8.
May I approach?
yes, because I'm Council Pro. Because my 7 of 8 is this one.
Yes.
Okay.
Perfect.
I
believe that's correct.
Maybe I was looking for a header, so
Yes.
that's why I was, okay, go ahead.
Thank you so much, Your Honor. Appreciate the court's patience. Please, Detective, you're on this page.
Can I put a little dot on where I'm talking, because they're small prints and I'm having hard time.
Yeah, of course. Whatever you need to do. That's your copy. The court has its own copy.
So the part that I'm starting is says 2023-11-50T 23. That's where, so it's about halfway through the page. 2308.
All right.
That is where it says J. Flintoff at Scioto Township.
And what does that column represent?
So we have one column that has the date and time stamped to the last second, and then you have the name of person that was sent the email to, which is J. Flintoff at sciototownship.org. Then we have the subject line, which is forwarded external RE Election Commission WF. The originating is the Will W. Hathaway at sciototownship.org. And then in front of it, at the very last column, on the rightmost column, has the IP address, 107.0.218.115, which is Scioto Township's
Okay. So as you began your message trace, that was one of the first things that you looked at?
That was one of the first things that I saw. That was the issue. Back to the
And after looking at that, what did that, what did you learn from that?
that an email was indeed sent at 23:08:38, which is UTC time, local time would be 6:08 p.m. and 38 seconds. An email was sent out to J. Flintoff using bouncing off of the Scioto Township Wi-Fi. We also have the name of the subject line for that.
What are these other entries at the same time, just very, very small units of time apart that say journal?
Sure, the computer does, processing unit does a lot of processing. So there are a lot of things that happen. As I mentioned, the server log logs in any transaction that happened regarding that particular email. Here we have the journal. Journal is the basically right ahead kind of, it's the older version of the write ahead logs. So the computer is not putting this into its hard drive yet. It's what's called 30 pages in the RAM right now. And before it gets cached in back to the hard drive, that's what it's showing. It's not like a bunch of emails went out, it's just one email, the rest of the computers.
And do you notice anywhere in here where you can see where a different or maybe a later time or anything else that you observed, or is there any other?
So there, the email that went out at 23:08 is followed by 3:08, 39 seconds. So this is 6 hours later. Mr. Hathaway's email was used to it looks like a reply email. It looks like a different IP address was used to send this email with that subject line.
You said about 6 hours later? All right. What did you do next?
Then I basically started asking questions. Again, I was getting to the technical part of it, even though I was still assisting. And those may have not known what to ask, so I ended up asking Mr. Hathaway several questions about wherever I was. And then I asked a later time. I asked Deputy Bloss to get the laptop.
So at this point, you've just analyzed the server logs.
Yes.
What happened next?
So can I look at my report?
Absolutely.
Did ask, reach out to the IT person, Chris Bailey. I did reach out to Mr. Hathaway. I analyzed the server logs, and then I received a laptop and did the forensics on it.
How did you complete the forensic imaging or download?
I usually use FDK Imager that I've been using for the last 20+ years, and then I tried to use FDK 7.6. I got errors. I tried Axiom and other forensic tools. I got errors, and then I had to upgrade FDK to version 8 and successfully acquired the.
This software that you use, what kind of software is this?
It's a forensic tool that I have been using. Anyway,
Is it available to the general public? Okay. And how do you get it, or how is it given to you?
The county purchased it. It's about a $10,000 a year.
What did you do after you were able to image the laptop?
Once I did that, and then I started. Well, the imaging part of it is you just create a file, a bunch of files. These are compressed files, and you have to actually use acquisition to parse out what these files are. What's an email inside this? What's a picture inside of it? All that. So that acquisition part of it took place in FDK version 8. Then I started analyzing. Again, we go straight to what matters in this case. I went straight to the email. I noticed that the email application.
What's the email application on this laptop that had been deleted?
I'm sorry.
What was the email application on this laptop that had been deleted?
Oh yeah, it was Apple, desktop version Apple.
And do you have a term that you use when you're looking for pieces of evidence within a computer?
Yeah, they're called artifacts.
Right. Were you able to locate artifacts related to this email?
Yes.
What were you able to locate?
So Apple's I was initially at the general findings and finding out when this application was installed. Some inquiry on that, and when it was deleted.
When was it deleted?
It was deleted at 6:24, that same day when that email went out.
And what happened next after you were able to look at that?
I continued with just general looking up at I did some inquiry on who was there operating the laptop, and I also wanted to see if there was any key fob information, people entering the township hall, things of that nature, and pretty much.
What happened next?
So after that, I did some. I usually search for a case like this, again, specific to this case. I wanted to see if there's any possibility that Mr. Hathaway would have get into that laptop when he was in possession of the defendant, and I checked to see if there are any viruses in there, any remote applications. I didn't find any remote applications. No, not even artifacts.
What is a remote application, for the record?
It's like a Zoom call. Sorry. Yeah, it's like the team viewer, a bunch of applications that you basically take control of the other laptop in a distance.
Did you find any evidence of that on this computer? Did you find any evidence of a virus on this computer? What else did you do in part of your investigation?
So after that, I went to, because the email was deleted, the email application was deleted, I had to resort to the database called the search database within Windows. And its functionality is basically to, we refer to it as Windows spying on you, but truly what it does is that it tries to maintain to find out what is happening to the computer, so that when you're looking for something, you can actually search for it. And it uses this version of the laptop. It's Windows 10. It's using an older version. It's called the ESE database. It's kind of a almost text-based database. Things have evolved tremendously since then. So I went into to check for that specific email to see if there are any artifacts left behind of that particular email.
Were you able to find any?
I was.
What did you find?
So I found it in the search. So this is not the email. This is not the actual email. What search does is that it records portions of the user activity. And in this case, I looked at it. Well, this is not automated, provided by the forensic tool. It is the manual carving of the data. So I found that email and I carved, and at the bottom of it, this is on page 8 of 11 of my report.
The first set of 8, the first page 8, correct? So on the first page 8 is where we're looking now, right?
Right.
And this is the page that talks about hexadecimals?
Yes.
Okay, we'll come back to that in a second. Please continue.
So this is, as you can see in the screenshot, on the top portion where the numbers 1 and 2 can be seen, that's the actual one. It's a hexadecimal. It shows the forwarding address, which is the same as.
I'm sorry, Your Honor, can I find out where we are? I'm not tracking where he is.
Page 8 of
8 of 11, which would have been starting at the beginning of the.
Yep. I also checked this long thing, yep, for the possibility of a scheduled email.
So the portion on the top that has numerals 1 and 2, that is what is presented to me. the big middle portion that has numerals 4 and 5, that's the tool that I use to interpret the number 3, that's a tiny little date timestamp at the bottom.
And what are hexadecimals?
So that's how computer talks. It interprets zeros and ones into hexadecimal.
So rather than binary, it has a different language?
It's based on zeros and ones. They're converted. Other than putting a bunch of zeros or just one, right? It's using that to simplify, make it shorter. So I found that, and I knew that where the time stamp was, so I located it right under the entry, and it is in hexadecimal, and I used a tool called Beagle and turned it into English to a readable format.
And what were you able to determine about the email in question?
So I saw that the search database you have when the application was touched, in Linux touched or opened, access. And then you have the closing of it when the activity is done. And then you have a third time, that is when the database is tabulated. So the first and the second, the first one here is showing when this email was accessed. It was accessed at 6:08:00 on 11:15. That's what it's showing.
All right.
Now,
what did you see? What else did you see about this email?
so that takes us to the next page, which is the second entry in the search database. And that is the same thing on the top. This is top very bottom portions from the computer. The middle part is my tool to interpret it. And as you can see here at 6:08 and 37 seconds, this transaction was done. So
what was this transaction?
This transaction was opening the email at 6:08:00, and then the user was done with that. We don't know what happened. He actually did what the user did, but the transaction was completed 37 seconds later.
Do schedules send emails create red artifacts?
No, they don't.
All right. Is the first artifact in the hexadecimals that we see on page 8 a red artifact?
Those are actually the computer marks it as red.
Ah.
That's what it does. I always try to be cautious about that. I use the word red in my first report, just following what the computer said. But I wanted to be more accurate. So my supplement report after that, I mentioned this and I said that I erroneously said red. The computer says so. I would change that to
Accessed. So does a schedule send email create an accessed artifact? It does not, correct?
No, it doesn't. If something is scheduled, you're not gonna see it.
Okay.
Because it's not done by the user.
Based on your expert opinion and these artifacts, are you able to determine if a human being opened this email?
Yes.
And what is your opinion?
My opinion is that it's the user double click on that email and open it. That's
And what happened 37 seconds later?
I don't know what happened, but for that I have to refer to the server log. Server log is showing that was sent at the exact time plus 1 second. So at 6:08:38 seconds, 37 seconds, that email was sent.
So we have an artifact on the laptop. It's 6:08:37 seconds, and then we have a server log showing a sent email at 6:08:38 seconds. What did you do next?
Then I checked for event viewer. Usually the event viewer gets us some system information which that we didn't have. And then, but at that time, I thought that I advised the township supervisor at the time, Mr. Hathaway, to it's issued with a couple of things, security wise. And then operating at Scioto Township. I knew that that email was sent from Scioto Township based on the IP address. I knew that the email was open at 6:08, and I knew that email was sent at 6:08:38 seconds. And based on all of that, I closed this case and turned it over to.
At some point later, did you complete another expert report in this case?
I did. This happened about a year and a half, I believe. If I could.
Yes, I'll have it for you here in just a second. Karen, may I approach the witness in the court with People's Proposed Exhibit 4? Thank you. Detective Parvis, I placed in front of you what's been marked as People's Proposed Exhibit 4. What do you recognize this to be?
This is my second forensic report, and this was after myself and Assistant Prosecutor Childers and the two defense attorneys met the prosecutor's office.
And is it a fair and accurate copy of that report?
Yes.
Does it contain your expert opinion analysis of the evidence in this case? Move for the admission of 4.
Objection, hearsay, same reasons as before.
This is a report that is his conclusions based upon his analysis.
Further analysis and investigation, Your Honor, that's correct.
And this was, I mean, the participation in this was actually by all parties.
Yes, I believe so.
At this point.
I don't think the defense attorneys are named, but my understanding is that defense counsel in the courtroom was one of them.
Yes, Mr. Bellatter's name.
Oh, I'm sorry, maybe in a different area. I'm looking at a different part.
Page, well, named, but it's really referenced to.
Oh, yes, I see it lower here. Yes.
For defensive objections, I'm going to admit the report.
Thank you, Your Honor. Detective Parvis, when you completed this report, what were you attempting to, what hypothesis were you testing?
What happened was that the defense had issued 2 emails, 2 pieces of pieces of paper. One was showing that an email was sent twice, and another one was that a Zoom call that was supposed to go out on November 13th, was a scheduled meeting on the 13th, was actually sent out on the 15th.
Were you able to verify those with server logs? No. Were they presented to you with server logs?
Well, that was the main issue because they were not in the server log. So when you're looking at November 15th activity, you don't see the Zoom meeting invitation going out. That everything be on that server.
Did you do any further investigation contained within this report?
Yes, I actually started. I went and talked to Mr. Hathaway, and what happened. He sent me an email back, and I copied our email, minus the times of the dates. But what he told me, and I copied that basically. Forward. And then we that's pretty much the
Is this the shortest of your reports?
this
Okay. And at some time later, did you actually complete a third forensic analysis and report for this case?
yes.
And Your Honor, may I approach the court and the witness with what's been marked as People's Proposed Exhibit 5?
Yes.
Thank you. Detective Parvis, I placed in front of you what's been marked as People's Proposed Exhibit 5. Do you recognize that?
I'm gonna object for.
Yes, same objection.
For hearsay, there's less hearsay.
Okay, same ruling, same ruling. Five's admitted.
Thank you, Your Honor. We'll shortcut the process a little. Detective Parvis, what is the date of this report?
This one is on April of this year, April 8th. Of this year.
All right. And what did you examine in this report?
Specifically, the defense had hired a forensic examiner to over the findings on the same laptop. I provided them the image, the forensic image, and then in return, I received a report by the forensic person, and this is my counter to this.
So starting at the beginning, which of the claims or hypotheses in that report did you disprove?
This is, I refer to the forensic examiner by his last name as Lieb.
Lieb as in boy?
And the first thing that I went over was that he stated that, can I give a summary of what the defense's forensic examiner said in the report?
If it's part of what forms your expert opinion, you may.
Yes, it's, this was usually when we do computer forensics, it's based on what we see in as evidence. It's completely evidence-based analysis. Here, the defense examiner, what he did was that they had an idea in their head that there was some sort of conspiracy.
You're not going to object to the characterization of what any defense expert had in their head. I think this is inappropriate speculation. He can give his opinion, but he can't describe.
Yeah, but he's describing it as how he sees it based upon then from that his analysis. So certainly you can question him on what may be the premise of what he's seeing, which may or may not lead to his conclusion.
I have no problem.
I think certainly he can state it, so objections overruled. But
So you're talking about an evidence-based versus what you saw here. So please continue.
Yes, I'm not trying to read, but I'm just based on what I read. The defense examiner was trying to do what's called a Texas sharpshooter fallacy, which is when there's a big difference between shooting at a target and shooting at something and drawing a circle around.
Oh, okay.
That's what they were doing. They started with an idea that there was some sort of a conspiracy, and then they expanded on that following that. And my second page of the report has a direct quote on that. And I started by saying that should I read what the examiner said.
It's in evidence. You don't need to, but you can start talking about what your conclusions were based on this report.
So the initial part of it is when the login time was, which is correct. That's what I came up with too. It was at again UTC time 11:04, so it's going to be 6:04 seconds. Then the second part that probably the only second thing that I actually agreed with the defense examiner was that the Outlook was launched at 6:07. So they logged in at 6:04. Outlook desktop version was launched at 6:07.
So you agreed with those conclusions.
After that, part of it. There are actually two additional things that the defense examiner did not include in his report, and that is between 6:04 and 6:07. There are two additional things that happen, and that is the Zoom application appears to have been activated at 11:05 and 11:07.
What did you look at next? Or what else did you see?
We also have at 11, again, I'm mixing these. I'm going to go with local time, so there's no confusion. At 6:08, we have two event ID numbers, 325, of which is basically the computer is rejecting the user's access. Its access is denied. The user was trying to access something that they were denied. After that, one of the things that the defense examiner was saying was that their idea was that Mr. Hathaway was somewhere else and forwarded that email to Jay Buntoff, and the defendant had nothing to do with it. And the problem with that was that we have the server logs, and it's showing that it was coming from the South Township Wi-Fi. It was hitting the South Township Wi-Fi. We also have the artifacts of that email, as I mentioned in my first report that I manually carved out, that very laptop was involved in that email sending. So we have the location and we have the device. And the defense examiner completely ignored all of this and just pushed on with the idea of the rest of his report is pretty much talking about I had to mention in my report, I referred to the email that was sent out that we are here for as the election email.
The election email? Okay.
And the defense had, in my second report, as I mentioned, we had a meeting with the defense and they kept bringing up this Zoom invite that was supposed to be scheduled for the 13th, but it was set on the 15th. And at the same time, or almost at the same time as when the defendant was operating the laptop. And the defense examiner were basing a lot of their goal to try to prove that the email invite and the Zoom invite and the election email were sent at the same time. And that's why there's somehow Mr. Hathaway was somewhere else and sending. So, and that's I'm not going to read it verbatim here at the bottom of page 3.
And that's an excerpt from the other report, correct? Okay.
And then going to page 4, what else did you do when you were analyzing this again?
So even though I had done this before, this time I went to the automatic version of this email, that election email. So on page 4 of my report, you'll see that I have a screenshot of what Axiom is telling me that, as you can see, there's 3 transactions done by search. This is Windows search again. We're not looking at the email. That was deleted. We're not looking at Outlook. We're looking at Windows search tags. And as you can see, it's showing that at 6:08, I'm translating to local time, there's a user communication. It's tagging it as such.
Why is that relevant to your analysis?
Because it has to be, when you click on it, there's something, and I think it's an attachment to this report. There's a little signature at the very bottom, and it says MAPI. MAPI is a messaging application programming interface. And that is for Outlook, and it's when the user is actually interacting with the application. And based on that, Axiom, in this case, this is Axiom Forensics that picked it up, picks up on that and says, okay, this is a user communication they clicked on.
What is a user communication?
The user communication is a human being that is using MAPI, which is the email container.
Okay.
So it's 2 factors.
Not automated, not the computer. Okay.
And then you can see the second entry here, again, looking at search database at 6:08:37 seconds. This is the part that I had manually carved out. This is the automated version. As you can see, it says user communication. That's the column. That's because a user was using this. The last entry, as you can see, there's no user communication. This is because databases have those 3 actions. The third action is this is an entire semester of teaching it, but
Let's get the cliff notes.
make it much shorter.
Thank you.
It's basically so if you're just think of database as an Excel sheet. Something you're constantly adding things to it and constantly taking things out of it, you're going to consume your entire computer's processing power. What happens is that when a bunch of transactions are happening, for example, if you're on the internet, you're going from page to page, things are changing in your database as since the internet is actually in the backbone of it, SQLite database. So it can't just keep up with you. So
what does it do instead?
So what it does is that it actually bundles all these changes that have happened and puts them in your RAM. So they're called, these are 64 kilobyte chunks that are going to sit in your RAM. So if power goes out right now at that stage, you're going to lose all that activity. So if somebody was doing something nefarious at the time, you pull the plug, you're going to lose all of that because that's in RAM. Then there's several steps after that. I'm going to make them very, very short and say at the end of it, all of these old transactions wait until the computer is done doing its main primary transactions. So let's say your internet is more important to you than Excel sheet, than your database. So it's going to wait until you are done with your whatever you're doing. So it could take up to, sometimes I've seen it in more than weeks, that third entry is just blank because it hasn't written back into the database. It's still sitting on the hard drive. It's or in the form of a cache in the RAM. This is all automated. That third transaction is all automated. So that's what you're looking at. So we see at 6:14 p.m. The database actually recorded that finished its transaction.
Did you apply this Axiom forensics tool to these Zoom invites?
Yes.
What happened when you did that?
So when you're looking at the Zoom one, it's the same concept, but that's on page 5 of 14.
On page 5? Okay.
Which report is this?
Page 3. Report 3, page 5.
What we see here is the Zoom call, that the Zoom invitation. When you look at that, it says that 11:08:08, but you see the final category where the orange box in there is no user communication. This is an automated transaction. And as a matter of fact, the defense examiner agrees that this was an automated thing. The thing is that they didn't produce any evidence that this was an automated thing. Their mind was to go after making the entire thing programmed, pre-programmed, which is not the case. And we'll get to that why. And I broke it down into a more expanded version of it at the bottom of that page 5, what each one of those entries is.
And when these are artifacts as well at the bottom of page 5? What is the distinction between the two artifacts?
So one is a calendar, the other one is a sent item. It's accessing the calendar and it's accessing the sent item. That's the different paths.
Neither done by a user on the computer. Thank you.
Not on that.
Say it again for me, please.
Not on the 15th.
Not on the 15th. What did you analyze next while you're doing your expert analysis?
So here but first of all, you have to mention that this also, this transaction is not seen, I have to reiterate that it's not active with the server log. When any transaction happens that's pertaining to email, it should show in that Excel sheet that I had. It was not.
Are you familiar with the possibility to link a Zoom account to an email account?
Yes, I am. You have an add-on within your Outlook. Because the Outlook was deleted, the application, I don't know if it was an add-on.
So you can't speak to that because it had been deleted?
Yeah, it's one of those kind of an unfalsifiable issues that I can't say one way or another, because this is all happening a year after this was brought up to our attention. The server log doesn't last for, I've seen server logs that don't last more than 2 days. A year later, obviously was not there. So I don't have any basis for any of this. Just brought up something that got brought up.
What was the next step in your analysis?
So one of the things that I tried to still figure out what this Zoom application happened. Again, based on the evidence that I can see, there were 2 event IDs 325 that I said. That means that the user was denied access, which means that it could have been that when the defendant was opening Zoom application, maybe it was cashed out. Cashed out meaning it was in the outbox and it was sent when it was opened up. That could be a possibility, but one way or another, I cannot say what happened.
Okay, you cannot draw a conclusion about that definitive.
And then the defense forensic examiner also mentioned that verbatim, this is what he said prior to the forensic imaging of Scioto Township laptop used by Jillian Kerry on November 15, 2023 to conduct a Zoom meeting. All email contained within the laptop itself was permanently deleted beyond recovery.
Is that accurate?
That's not it.
Why not?
I actually recovered 69,000 emails.
And how did you do that?
So Windows has volume shadow copies, and basically in the background, every time you're installing something that is going to change things within the system, it creates a little shadow copy. It's not a backup. It's very technical, but it's a shadow copy. It's sitting there, but it maintains what happened before that. You can always go back to it.
Is VSC the term you would use for that, the abbreviation?
Correct.
And you were able to recover 69,000?
Yes, it was in the VAC, but the problem was that the VAC happened on November 13th, 2 days before this happened at the township. And so I don't have the email from the 15th. However, I was able to recover that Zoom invite, which is at the bottom of page 7. You see that email was sent. It's got a timestamp when it was sent. Start time and the end time, and it's all on the 13th when it was clicked on. I don't know if it was sent or not, but all I can say based on what I'm seeing is that it was clicked to be sent.
What happened next when you were completing your analysis?
So just to verify that Zoom invitations use a unique Zoom numbering system for the planned meeting, and that number corresponds with the exact number.
Represented on page 8?
Yes.
Thank you. What was the next step in your analysis?
The next one was that I believe this is when the defense examiner stated something to the effect of 9 emails were sent at the time when the defendant was operating the laptop. That is completely wrong.
How come?
Because I manually looked at this laptop. I ran 2 forensic tools that I've used for more than 2 decades, and they never showed that. And primarily because the email server logs don't show anything but that 1 email. They don't show 9 emails. This was that's why I always teach my students that you have to manually check anything that's going to so
Yeah, actually, I could use a break if you don't mind, Your Honor. That would be okay.
Sure. I was gonna, we're about 5 minutes off of where I was gonna call for one inning, but this is a good point.
I think so.
Let's take a break. All
Thank
right,
you.
quarter standard. How much more do you have of your, no, I know you have, of your questioning?
Just the end of this report. We're on page 10 of 14.
Okay, and then we'll see where we end up. So, all right. Quarter standard. All right. A hint that we'll finish your direct examination and then come back, get another day and begin with cross.
No objection at all, Your Honor. I completely understand.
All right. Okay, so we are back on the record in the case of Jillian Kerry. Sir, I just remind you that you're still under oath since we took a break. I'm sure you know that.
yes,
You may continue.
Thank you, Your Honor. Detective Parvis, looking at page 10 of your third report, what was the next part of your analysis? I think we left off when we were talking about some of the logs related to the Zoom and the email and what you were doing next as contained in your analysis on page 10.
Okay, one-page report at 9.
I'm sorry, 9, I apologize.
It's the mistake made by the forensic examiner, the defense's examiner. As you may recall, I showed you the 3 stages of search database. The first time when it's accessed, the second time when it's closed, the action is done. The third one is that automated part. The transaction or the database is happening. The defense's examiner looked at that third column. In his forensic software, that column is named search gather time, and he thought that that when the user was gathering the information somehow, it had something to do with the user, which is based on if one of my students said that, I would tell them to read the book over again. This is just complete ignorance of how databases function. The next phase of this was that the defense examiner, based on many mistakes that I have, some of them I have explained here, typed a 10-page portion of his report is about this experiment that he conducted, showing that if you turn off your Wi-Fi and type an email, it's going to be in the outbox, and then when somebody opens that laptop, that email is going to be sent.
Why is that not relevant in this case?
Because number one, we know that this was trying to say that somebody other than operating that laptop sent that email. It's not relevant because that laptop itself is telling me that somebody who was operating that very laptop sent that email. We have the artifacts in that laptop. Number two, we have the bouncing off of the San Township Wi-Fi. We know the location of that laptop. You know who was operating behind that. It's completely, again, this is the drawing a circle around this target. And then they went through 10 pages of doing an experiment, showing that if you turn off the Wi-Fi, close the laptop, and the next person, when they open up the laptop, it's going to send that email. That's the gist of it, is I'm making the 10-page thing.
What is a Wi-Fi event log?
The Wi-Fi event log actually shows when you're turning off the Wi-Fi on a computer, and I provided a screenshot of what it looks like on my computer, and that is missing in the laptop. So the laptop is not showing that the Wi-Fi was turned on.
Okay. And the screenshot that you provided, that's on page 11?
That is page 11. On the top, you have my computer. When I turn it on the laptop, you're going to see a firmware that is operating that particular Wi-Fi card. Mine, it's version 2, and the one on the laptop was version 6. So when I'm looking for any activities by that firmware on that laptop, I see that the last time that laptop was even accessed, that driver was even accessed, was on November 8th, which is 7 days before this event occurred. So
Are these also artifacts? Would you call these artifacts? And you don't see any support for the Wi-Fi having been turned off and on?
I don't see support, but I see contradictory artifacts contradicting what the defense examiner was saying.
Is it your expert opinion the Wi-Fi had been turned on and off on that date?
No, it wasn't. It's we never had any indication by the defendant when she talked to Deputy Phillips. We don't have any indication from the log that Wi-Fi was turned. Then the defense's examiner constantly brought up this issue of the Microsoft audit log.
What is a Microsoft audit log?
I guess at this point, I'm going to object to this testimony about what our examiner said. We have not called that examiner as a witness, and it's the prosecution's burden to prove their case. I don't think it's necessary, and I think it's wasting the court's time and everyone here's time to talk about what in a report that's not in evidence, and our expert is not here to defend himself on his report. So I think that's not appropriate.
Well, but I would imagine that, and just anticipating that your questions to the detective are going to go from some analysis of your expert. I mean, would I, whether right, wrong, or, okay, thank you. Thank you. All right.
Thank you.
Go ahead.
What are Microsoft audit logs, please?
It is it's part of the subscription with Microsoft. It's Microsoft will maintain your actions as if you're in front of your laptop. So if you delete something, an email, you do any kind of activity with your email, how much you pay for the amount of storage that it's going to keep it for as long.
Is it the same thing as a server log?
It's not. The server log is by far more particular than the Microsoft audit log actually pertains. The server log pertains to this case. Microsoft, all it's going to provide is that an email at that time was sent. I know that based on examination of the laptop and based on the server logs. The examiner kept harping on that over and over again. I did contact the IT Township, Township's IT person, and I asked over and over again, not for particularly Microsoft audit logs, because it is the township, you're going to have full access to what everybody did. I didn't want that. What I was specifically asking for was that they're using the TFI archiver, which in my experience is the best foolproof and you cannot contaminate that server. It's made for the discovery, so you can actually go in and without worrying about any contamination, extracting information. I wanted that, and I knew that the township was using my archive. That's what I wanted.
Were you able to get that?
Over and over again, I contacted the IT. Even I was hopeful I could get access to it a year later when my second report was done. I could not get it.
Directing your attention to Appendix A in this report, which is the last page of it. Can you explain to the court what this shows?
So this is the database entry in, I'm reiterating that, and I'm actually this time, the same screenshot in my first report did not include the mappy note at the bottom where the computer says red. And I just wanted to bring attention to the fact that the computer says that email was read again. I hesitate to say it was read, I say it was accessed.
And Your Honor, may I approach with Defendant's Exhibit G that has been admitted into evidence?
Yes.
Detective Parvis, do you recognize the Exhibit G I've just placed in front of you? And have you seen that before?
I saw it when you pulled it up here today. I think I vaguely remember this from our meeting last year with the defense.
Okay. And were you able to do any analysis based on this?
No, it's just a paper. This is just a printout of some email. There's not even a header information about any of this. Not that the header information give much information. I do need the server logs. I do need to find out. It's the question that it's coming back to me. It was about something about why it was sent twice, an email was sent twice.
And did you do any analysis or expert
There was
forensic? Why not?
The problem is that this is there's this is the defense's paper. It has nothing to back this. It could have written that it was busy. Emails are not made to be instant at all. That's not emails are there for. Maybe you're at the mercy of the server, the email server. And at this point, maybe the server upgrades, maybe it could be anything that caused this. But this is just something that this is one of those unquantifiable claims. I don't have anything to research. They will have.
Detective Parvis, in your expert opinion, was this email, the election email, sent automatically or by a person?
It was sent by a person.
Was it accessed automatically or by a person?
By a person.
Who was it sent and accessed by?
Based on the interviews with the defendant was there operating that laptop at the time when this email was sent, and we know the location based on both the defendant's statement and the Wi-Fi.
Thank you, Your Honor. I'm done there.
All right, very good. So what we will do, having finished the direct and detective departments, is we'll, as indicated with counsel, will adjourn to another date for the beginning of cross. What dates did we have?
Tuesday.
Okay, all right. I can continue this. This works, we can do.
Let's find her on my list. Okay, I find her and.
Shauna Picket, or Zachary Picket.
Very well, next.
No.
Oh, I'm sorry.
No. Rhonda Lazley.
Sorry. All right.
Alberto Bloss. BLAS.
Got it.
And Shauna Thames, THAMES.
Thank you.
Okay, slide your kid right over here and we'll get right next to me, to the picture.
Which one do you have first?
I have Anita Moore.
Thank you. And you, there we go. All right, Miss Moore will be on the record in 2024 TR 3278, State of Kansas versus Anita L. Moore, Jared Regier for the state, Defendant Moore in person and pro se. Ms. Moore, when you were here last, you told me that you were going to look into diversion for the 1 count of registration. Did you apply?
I didn't have the money yet right now for it, or I would have.
All right.
I'm a senior on a fixed budget.
Let's see. Well, how are you going to proceed today? Are you going to enter a plea of guilty?
Well, I'll
guilty
have
or
to.
no contest.
I've never been in trouble before. I've never even had a warning, so I don't know what to do, what I'm supposed to do.
You can plead not guilty and set it for trial. You can plead guilty and proceed with sentencing. You can plead no contest, which means you don't admit it, but you don't deny it either. You'd still be found guilty and proceed with sentencing.
Well, I mean, I am guilty of it. I'm not on purpose, but yeah,
All
I'm
right, so
guilty.
what are you telling me? You want to plead guilty or do you want to plead no contest?
No contest.
All right, now. Are you proceeding on your own behalf today without counsel?
Yes,
And is that your own free will, doing that voluntarily?
yes,
And you know that you can hire an attorney, and if you can't afford an attorney, you could apply for court appointed.
yes,
All right, and knowing this, you're going to proceed on your own behalf without an attorney today, is that right?
yes,
All right, and you said you want to plead no contest to the one count of driving without a registration. No contest, do you mean you don't want to admit the charge, but you don't want to deny it and take it to trial either?
right.
And is anyone making you enter this plea today by any threats or promises?
No,
Very well, I find you are, that you have first of all, on the record, knowingly and voluntarily entered a waiver of counsel. I'll have the officer let you sign that, and I'll have the docket notes and the journal entry reflect the same.
print and then sign.
Yeah, I just sign it up and yours. Thank you. Okay, Judge, she's got it signed.
I see, thank you. Now, Ms. Moore, I also find that you knowingly and voluntarily entered a no contest plea. In order to accept that, Mr. Regier, can I get a proffer of evidence from the state?
Yes, Your Honor, if I may.
Yes, please.
Your Honor, were this case to proceed to trial, the state's evidence would show, pursuant to the ticket, that a stop occurred on December 10th, 2024, involving a 2022 GMC on I-35 at milepost 95. The state's evidence would show, and the state's understanding is that that is still within Butler County boundaries in the northeastern quadrant of this county. Besides citing the defendant for a violation of KSA 8142, the officer specifically noted in the attached court comments in apparent shorthand that the tag had expired in August of 2024, which would appear to be prior to the December 10th, 2024 date, notwithstanding the what the defendant may or may not have subjectively considered at the time of the stop, as what would appear to be based off of the defendant's statements on the record. The state's reading of the statute is that is not relevant for purposes of this charge.
I do find a basis exists to support the no contest plea and find the defendant guilty. Recommendations for sentencing, Mr. Regier.
$50 fine, court costs, suspended jail sentence for 30 days, subject to a 6-month non-reporting probationary period. I will, of course, defer to the court on any issues concerning repayment of this case.
Ms. Moore, you're welcome to say anything you'd like on your behalf prior to sentencing. You don't have to, but you certainly are entitled to if you like.
No, I was just shocked when he stopped me because I had no idea it was expired. I was in bedridden for 6 months because I hurt my spine and they couldn't get me in for surgery till January. And when he stopped me, I said, "What?" I was totally amazed. And I said, "You mean to tell me I've been driving all this time and nobody's ever stopped me till now?" He said, "I guess not."
All right, well, at this time, I will follow the state's recommendations. Your fine is $50. Your court costs are $108, so the total due is $158. I am giving you a suspended 30-day sentence. You will not have to serve that so long as you successfully comply with a 6-month non-reporting probation. That probation only has 2 conditions. The first one is that you not violate any laws during this 6-month probation, which starts today. The other is that you tell me when you can pay the $158, and I'm going to hold you to it. You do it for 30 days, 60 days?
Probably like 60 days because I have my house taxes due.
All right, I'm
And I'm on
gonna,
a fixed income. I'm a senior. I'm
okay.
poor.
60 days it will be. And you stop by the clerk's office to find out the different payment methods. Try to pay a little here and there so it doesn't
I was
just
gonna say, can I
snowball.
pay on it as I go? Okay, cool.
As long as it's all paid within 60 days.
All
But
right.
if you violate the law or if you don't pay, those are violations of your probation. And your probation could be revoked and you could serve 30 days in jail. But if
That won't
you,
happen, sir. Ma'am.
I'm gonna hope that you're right on that. So, yeah, like I said, stop at the clerk's office and they'll tell you the different methods of payment. Anything else that we can help you with before I let you go, Miss Moore?
No, just thank you for your time and have a great day.
Now, you are welcome and you are free to go unless Mr. Regier, you have something else?
No, Your Honor.
All right, thank you, Miss Moore. We'll be in recess.
Thank you, ma'am.
You're welcome.
Thank you.
Next one up is Zachary Picket. Where's the?
I would ask that in addition to Zachary Picket before the court, that the following defendants who have the same charge pay close attention. Charged with registration, I'm addressing Alberto Bloss, Rachel Crook, Liesel Dahl, Kimberly Aaron, let me see. Audrey Patterson, Jake Reynolds' son, Christopher Smith. Some of the rest of you also have the registration charge, but you would have additional charges to address. So I'm going to go over Mr. Pickett's rights and charges, and those of you with the same charge will have the same rights and charges. So Ms. will be on the record in 2025 TR 513, State of Kansas versus Zachary Allen Pickett. Jared Regier for the state. You are Zachary Pickett.
Yes.
Mr. Pickett, as I indicated before we went on the record, you have one charge, driving with an unlawful registration, maybe an expired tag. This is called an unclassified misdemeanor. The maximum penalties include a $2,500 fine, and the sentencing range could be 30 days to 6 months. But probation is an option, and as you heard on the case of registration before you, the fine is usually much less than the maximum. But because there is the potential for a 6-month sentence, although I don't know that we've ever seen it imposed, you could apply for an attorney. But first, I would advise you that you have the right to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply for court appointed, or you can waive your right to attorney as the lady before you did and proceed on your behalf. You can plead guilty and proceed with sentencing today. You can plead no contest, which means you don't admit, but you don't want to deny and take the charge to trial. You'd still be found guilty and proceed with sentencing today. You also could plead not guilty, and we would set this for trial at a later date. If you have a good record, you might be eligible for the county attorney's diversion program. You would have to apply. You do that online today or in the very near future. And then you wait a week or two and see if you've been accepted. If you're accepted, you will get a contract in the mail from the county attorney. You will sign that and send it back. Now, both the application and the acceptance have additional fee requirements. You still have to pay your fines and costs and the diversion fees. I will give you one opportunity to do that, but if you come into the next hearing and haven't done that, more than likely we'll proceed and you've waived your chance at diversion. So at this time, Mr. Pickett, do you want to look into diversion or proceed in another way?
I'll just proceed, no contest.
Before you do that, I need you to acknowledge that you want to proceed on your own behalf today. You're giving up your right to counsel.
Yes.
Okay.
Yes, ma'am.
You'll need to read and sign the form the officer has.
Okay.
He's got to sign, Judge.
Okay, and I'll have the record reflect that both in the docket notes and the journal entry. And Mr. Pickett, you said you want to plead no contest to driving with unlawful registration.
Yes, ma'am.
Is anyone making you enter this no contest plea today by any threats or promises?
No.
And you understand that you have the right to trial, but you're giving that up with the no contest plea?
Yes. Yes, ma'am.
All right, I was thinking, I'm sorry.
Oh,
All right,
sorry.
Mr. Regier, have you a factual basis to support a no contest plea?
Your Honor, were this case to proceed to trial, the state's evidence would show, both through testimony and through the ticket, that a stop occurred on March 2nd, 2025 at the intersection of K-254 and Ohio. The state's understanding is that is between Towanda, El Dorado, and Augusta city limits, well within Butler County boundaries. The stop appears to involve a 2000 Oldsmobile. Besides citing the defendant for a violation of KSA 8142, the officer specifically noted a license year on the vehicle of 2024, which would appear to be prior to the March 2nd, 2025 stop.
The court does find that the defendant has knowingly and voluntarily entered a no contest plea today, and that the state has provided a factual basis for that plea to that charge. Therefore, the defendant is found guilty. And Mr. Regier, recommendations for sentencing?
State is not opposed to a suspended jail sentence of 30 days, subject to a 6-month non-reporting probationary period, Your Honor. In this matter, the state is, however, recommending a $50 fine and court costs.
Anything from further, Mr. Pickett?
No, ma'am.
Then I will accept the recommendation of the state. Mr. Pickett, you are fined $50 and assessed $108 for a total of $158. You're given a 30-day suspended sentence. You will not serve that as long as you successfully complete a 6-month probation. You will not have a probation officer, as this is non-reporting. Your probation has 2 conditions. The first is violate no laws for the next 6 months, and the second is to pay the $158. Can you pay that today, or do you need some time?
I'll pay it today.
Very well. I will order that that be paid by noon today. And then the only other condition is that you violate no law for the next 6 months, and the case will close.
Sounds good. Thank you.
Thank you, sir. And you are excused.
Okay, Judge, we'll pick up Alberto Bloss because I believe he has that same charge.
Okay. Good morning, sir. You're Alberto Bloss.
Yes, Your Honor.
Will be on the record in 2025 TR 492, State of Kansas versus Alberto Bloss, County Attorney Jared Regier for the state, and Mr. Bloss appearing in person and pro se. Mr. Bloss, did you hear the 2 cases that went before you this morning?
Yes, Your Honor.
Do you have any questions about the registration that we've gone over several times or a couple of times now? As far as possible penalties,
Yes, Your Honor.
I can give them to you again. The sentence could be 30 days to 6 months, and the fine could be up to $2,500. And you do have the right to a trial. You have the right to hire an attorney, and if you can't afford one, you can apply for court appointed. Do you wish, or you can waive your right and represent yourself. How do you wish to proceed on the issue of attorney?
I'll present myself.
But if you would confirm for me that you do understand you have the right to hire an attorney, and if you can't afford one, you can apply for one. You understand that, sir?
Yes, Your Honor.
And knowing that, you wish to waive your right and represent yourself.
Yes, Your Honor.
Is anyone making you waive your right to an attorney today?
No.
All right, then if you'd look at the form before you and sign that if you agree.
He read and signed it, Judge.
All right. The record will reflect that he has signed a waiver of counsel and orally waived counsel. That can appear in the docket notes in the journal entry. And Mr. Bloss, your options are for pleading not guilty, and we will set this for trial at a later date. Or you can plead guilty today, admitting the charge, and we'll proceed with sentencing. Or you can plead no contest, not admitting the charge, but not denying it, or because you don't want to take it to trial or admit it. You would still be found guilty, and we'd proceed with sentencing. Depending on your record, you might be eligible for the county attorney's diversion that I mentioned a couple of times before your case, but it looks like you have quite a few entries. At least this is at least your third entry since 2023, so you may not qualify for diversion. That's not my determination, but I would just bring that up. At this time, how do you want to proceed on your plea or diversion?
What do I do if I got it taken care of?
Tell her.
Oh, Your Honor, I originally went down to Texas to get my vehicle inspected and gave money to a family member to renew my registration for me while I came back to Kansas for work. And unfortunately, they didn't follow through, and I wasn't able to make it back down there due to my work schedule and, well, the distance. And in that time, I got pulled over by Officer Dottie, and well, I realized I had to take care of it myself. And since then, I got it taken care of and everything's in order. I got my registration updated and I have proof for it. And besides that, now, yeah.
So it sounds like you're telling me that you did drive without a proper tag, without a lawful tag? As
Yes,
in
Your
you're
Honor.
pleading guilty, is that right? Or are you pleading no contest?
Well, I went down there before my tags were expired. I went down there.
Okay, I just need to know, do you want to plead not guilty and set it for trial? Or are you telling me you are guilty, that you drove with a unlawful tag at the time of the ticket? Or are you taking a no contest plea where you're not admitting it or denying it?
No contest.
All right, by no contest, you don't want to admit it, but you don't want to deny it and take it to trial. Is that correct?
Yes, Your Honor.
I will enter a no contest plea for you. Mr. Regier, he's pretty much given me a factual basis himself, but if you want to officially give me a basis, I would listen to that.
Thank you, Your Honor. For purposes of establishing a no contest plea, the state would show where this case received trial that on February 26, 2025, a stop occurred on I-35 at milepost 76 State's understanding is that is well within Butler County boundaries, within close proximity to El Dorado city limits. The state's evidence would further show that the stop involved a 2018 Chevrolet. Besides citing the defendant for an alleged violation of KSA 8142, this officer would have specifically noted in the attached court comments that there was an expiration date of April of 2024, which would appear to be approximately 8 months prior to the February 26, 2025 stop. As this is apparently a no contest plea, the state would not be referring to any statements made on the record here today insofar as self-incrimination issues are concerned, but the state's evidence, the state would respect to submit is more than sufficient to sustain a factual basis for this case to proceed to trial.
I do find that the defendant has knowingly and voluntarily entered a no contest plea and that the state has provided a factual basis to support it. We'll proceed to sentencing. Mr. Regier, anything different than what you've been recommending this morning?
Your Honor, the state in this case is prepared to recommend a suspended jail sentence of 30 days, subject to a 6-month non-reporting probationary period. While the state does consider this particular case in its own case and does not consider itself bound by any prior recommendations made in unrelated matters, the state is not opposed to proceeding with a $50 fine and court costs in this matter.
Thank you. And Mr. Bloss, do you have anything you want to say before I pronounce your sentence?
No, Your Honor.
All right. Mr. Bloss, at this time, I am ordering a $50 sentence and $108 in court costs. The total due is $158. Can you pay that today or do you need some time?
Yes, Your Honor, I can pay it today.
Very well. Your controlling sentence is 30 days. That's suspended. So you will not have to serve it as long as you're successful in completing a 6-month non-reporting probation. It has 2 conditions. The first one is to pay the $158 by noon today. And the second one is to violate no laws for the next 6 months. As long as you comply with those 2 terms, we can close the case in 6 months. Do you have any questions about anything?
No, Your Honor, I understand.
All right, don't forget to stop at the clerk's office and we'll be in recess at this time.
All righty, good enough. Thank you, sir. Next one up, I have Rhonda Lazley. Rhonda Lazley.
Good morning, you're Rhonda Lazley.
Yes, ma'am.
Very well, we are on the record in 2025 TR 478, State of Kansas versus Rhonda M. Lazley. Jared Regier for the state. Ms. Lazley appears in person and pro se on 1 count of driving without proof of liability insurance. This is a Class B non-person misdemeanor. If convicted, there is a minimum fine the court must impose of $300, but the court could go as high as $1,000. There is also a potential 6-month maximum jail sentence, but the court could impose something less than 6 months and could give, and usually does give, probation. If your record is good, you may qualify for the state's diversion. It does require, in addition to payment of fines and costs, extra diversion fees, and it requires that you have current proof of insurance. I'm looking at your record that the computer file has. You have a few civil things. You have 1 traffic matter that is driving without insurance back in 2011. So I don't know if the county attorney would use the prior no proof of insurance against you or not, If you don't want to apply for diversion, or if you think you wouldn't qualify, and don't want to spend the application process and fees, then your options would be to plead not guilty and the matter would proceed to be set for trial at a later date. Or you could plead guilty and proceed with sentencing. Or you could plead no contest. That means you don't admit the charge, but you don't want to deny it and take it to trial. You do have the right to an attorney. You can hire any attorney or apply for court appointed if you cannot afford to hire. Or you can waive your right to attorney and represent yourself today. Do you wish to talk to an attorney about this Class B misdemeanor?
No, I am obviously guilty of the charge, although I was at the time unaware of the fact that there was no insurance current.
All right. And you're not going to be applying for diversion?
What would I have, what does that involve?
Well, you have to, I can't remember how much is I want to say 125 application fee, but I don't know for sure. And Mr. Regier, you probably can't tell me.
Your Honor, I do not have that information directly in front of me at present.
Okay, but anyway, you have to apply and then they run your record and see what your record looks like. And based on that and the current charge and how you probably treated the officer and so forth, they'll decide if you can have diversion. If they grant it, then you pay your $300 fine and 108 court costs, plus you pay an additional diversion fee. And you have to get proof of insurance to them, and they may make you do classes online. I'm not sure what all it involves. But you
Well,
first
I do have current insurance. I got it immediately after the fact.
Well, that's
As soon as I
good.
realized that it wasn't current.
Okay. But you do have to have a good record, and like I said, I don't know if they'd hold that prior insurance against you. They may, I just don't know.
And that one I had actually technically forgotten about. It's
Okay.
been a few years back and
2011.
yeah,
And then you have some civil matters that I don't know how they would address those, so.
some civil matters.
Yes.
Oh, my driver's license.
No, not on your driver's license, just,
Well, what other civil matters would I have?
well, you have some financial issues.
Well, yeah, we've always got financial issues.
Okay. And I don't know that they would use those against you. I have no idea. I wouldn't think so, but I
Okay.
don't.
Okay.
But how do you wish to plead today?
I will have to plead guilty because I obviously am.
All right. And you're going to represent yourself, is that correct?
Yeah, I guess because I can't afford a lawyer.
Yeah, but I told you if you can't afford one, you can apply and see if you qualify for court appointed if you want to.
Okay.
Okay, what?
Okay, I will do that then and get a lawyer.
You want to apply for an attorney?
Yes, please.
Okay, now everyone note, even though it's court appointed, they're not necessarily totally free. You may at the end of the proceedings have to pay a portion of that depending on your ability, if any, to pay that. So everyone note that. And officer, if you would please give her an application for court appointed attorney. And Destiny, when are we setting her court day?
I apologize, Your Honor, on a Wednesday, correct?
Well, she's applying for attorney, so let's go for Monday.
Absolutely. September 8th is our next date.
You must reappear September 8th at 9 a.m. You must fill out that application form and leave that for me today. And then you must call back Friday and find out who your court-appointed attorney is. And call that attorney as soon as you get the appointment. And make an appointment to see that attorney, or an appointment by phone is fine. Any questions? You need to be booked and processed, which means she needs to get her picture and prints taken, and I'm gonna give you $1,000 OR bond. Officers, have you already set that up with her?
Yes.
Okay. Mr. Regier, anything further?
No, Your Honor.
All right. Miss Lazley, anything further?
No, ma'am.
All right, thank you.
Thank you.
You are excused, but make sure you get those picture and prints and you sign that bond, because if you don't, you're probably gonna get arrested.
Yeah, I don't need that.
And you make sure you leave that application, fill out everything. Don't leave it blank. Make sure you sign it, make sure you date it. Leave it with either the officer. Is it okay to leave it with you, or do you want to leave it with the clerk?
I'm gonna have her fill it out and leave it with me at this point.
Okay.
Fill
You
it
don't-
out, bring it back, let me check it, and then
If you don't, again, you might be in contempt, because you said you want an attorney, you have to fill that out. And you have your
tearing this
court.
up.
Oh, okay.
Okay, again, Mr. Regier, anything further?
No, Your Honor.
All right, Ms. Lastly, you are excused at this time.
Okay.
But you
And
feel
the
better.
last one I have is Shauna Thames. Thames.
Yes.
Is it Thames?
It's Tim's.
Tim.
It looks like, yes, English River Tim's.
Thames. Well, now I'm confused. Tim's or Tim's? Tim's.
It's Tim's. It's Thames.
Okay, like the river Thames. Okay.
Yes.
Well, and even that people pronounce differently, but okay.
Right.
All right. We are on the record in case number 2024 TR 2705, State of Kansas versus Shauna Lee Thames. The state appears by and through Jared Regier. Ms. Thames appears in person and pro se. Ms. Thames, you were going to apply for diversion on count 1 involving unsafe connection of safety or towing equipment and no insurance. Did you apply for diversion?
No, I did not. I tried to get my proof of insurance, but I'm through Key Management, or not Key Management, I apologize, Key Insurance, and they've gone out of business, and so I'm having difficulties getting my proof of insurance at that time. The back insurance proof, and so I didn't do diversion because I just knew I could get I thought I could get the copy of the insurance, but I'm having difficulties with that. So I did not apply for diversion.
You had a 24 criminal case in Butler County. Did you get that resolved?
Yes. Criminal case?
It says a criminal case pending. Filed
It
on
was,
December 30th of 24.
it was for the no insurance ticket.
It was for another no insurance ticket.
No. This insurance ticket, this same one. I went
Well,
to jail.
This one shows, and the one we're here on today, 2705, shows an offense date of October 6th of 24. And then I see a 24 CR 548.
It's the only time that I've ever anything with Butler County.
Well, it says well, let me check on that with Mr. Regier, because it says it was filed December 30th, 24, and it is pending. So what can you tell me about that, Mr. Regier?
One moment, Your Honor.
What's for this insurance ticket? Insurance ticket, and so I didn't go to court, so then that gave me a warrant.
Hang on, but you're still on the record. Let's let Mr. Figure have a moment here.
Your Honor, the state would respectfully inquire as to that case number one more time. I do not appear to have that case on my docket sheet here today.
It's not, and as I look at it, it's actually, it shows up on her record, but it's actually captioned State of Kansas versus Jacob Lee Denton, and it's 24 CR 548. Do you know Jacob Denton?
Yes, I'm a housekeeper and assistant manager at the Economy Inn, and he had pulled a knife on different guests, and I'm the one that called the law enforcement.
Okay, so perhaps you're just a witness in that case.
Yes, yes.
Okay. That's your connection. You're a witness. I think.
Your
Mr.
Honor, in response to the court's inquiry, I have no knowledge as to any other currently pending Butler County cases involving the same defendant as a defendant per se, although I am showing a journal entry of dismissal in Butler County 22 MR 036. It would appear that that pursuant to that same journal entry of dismissal with prejudice, quote, the plaintiff moves that the above action hearing should be dismissed prejudice as the defendant signed a waiver of extradition.
Yes, I'm seeing that too. A 2022 waiver of extradition before Judge Crum. All right, so I don't know what, if any, impact those might have on your diversion application, but you're saying you didn't even try to apply?
No, because I had the insurance at the time, and so I just thought I could get the proof of it, even though it was a back proof of insurance, but Key Insurance has gone out of business and they're not responding back to me with my inquiries for proof of the insurance.
Well, if you had proof of insurance at the time, you probably wouldn't need diversion. The state wouldn't have to, but they might just dismiss the charge, even though it's getting some age to it. I'm going to set this for trial. When's our available trial date, Destiny?
Yes, Your Honor, that's going to be August 13th.
I'm setting this for trial August 13th at 1:30.
Okay.
You have until August 13th at 1:30 to get your proof of insurance to the county attorney.
Okay.
If you don't, I'm expecting the county attorney to have their witnesses. Yeah, I'm expecting you to have any witnesses, and we're gonna just find out about the nature of this and if there's evidence to convict, because you've had plenty of time to pursue diversion. You're gonna get a little bit more. And like I said, I don't know why you'd want diversion if you can get an outright dismissal.
No, that's why I didn't fill out the diversion. I didn't think I needed it.
All right, well, that's the order. And if you want an attorney, apply now, don't wait, or hire now if you can.
No, I would like to waive my right for an attorney.
All right, do you have a waiver form there for a deputy?
I do not.
If you get one, please.
We will.
I do have a question, Your Honor. With me going to file, it's okay for me not to have, I'm not going to represent myself, and I don't feel I need an attorney, even though we're going to trial. How does that work exactly?
Well, if you want an attorney, you hire an attorney. If you can't afford an attorney, you can apply, or you can waive your right and you'll just represent yourself. The state will have the burden of bringing in their officer that stopped you, and he'll either be able to say she didn't have insurance, and you'll be able to respond and say, I did, and here's my proof.
Oh, okay.
If you don't have proof, then you'll probably be found guilty and proceed to sentencing.
Okay.
But with what you're telling me, if you can get your proof of insurance between now and August 13th, get that to the county attorney, and they very well may dismiss that. But you still have the safety equipment charge.
I put chains on immediately. That's why he let me
I
pull
don't-
off the road.
I don't want
But
to
it
hear
wasn't
that right now. I want you to
Okay, okay.
address that at trial or the date we have set for trial.
Okay.
Anything further, Mr. Regier?
Your Honor, I believe there is still the issue of bond in this case. If the court is continuing the same, I am showing a bond was executed after a previous failure to appear in January of this year. The state is also requesting a formal ruling on the record as to whether or not the defendant has successfully entered a waiver of counsel in this matter at this time.
Has she signed that yet, Deputy? I haven't seen it.
She signed it. She signed the waiver of counsel.
You have that in front of you?
I do.
All right. I will find for the record that Ms. Thames has signed her waiver of counsel on the record, knowingly and voluntarily doing so. And that the matter is set for August 13th at 1:30. I am continuing the bond of $1,000 that she previously signed. Now, Ms. Thames, that bond condition now has the requirements that you reappear August 13th at 1:30.
Yes,
All right.
understood.
Thank you very much, and you may go at this time.
All right, everybody, I got a picture I'm going to show. This is this week. At a judicial conference in Texas. That's Judge Boyd getting to meet our very own Victoria Bernal from Judge Fleischer's courtroom. Victoria was kind enough to send this over to Court Vibes, and I just got permission a little bit ago to show it. So, oh yeah, there we go, Big Tiff. There's the picture. So that there again, that's Judge Boyd with Victoria. Victoria was starstruck, having a blast. And Judge Fleischer did not appear at this, so Judge Fleischer and Judge Boyd didn't get to meet up. So there's that, and I'm going to jump back off, and I'll throw it up on Discord.
Thank you very much.
You're welcome.
Okay, Judge, that's all I have here for
Okay,
now.
thank you. Well, I'm going to go back to the rest of you that have registration only charges. And we'll just start alphabetically. Someone needs to mute. I don't know who that is, but I'm getting some feedback. Jake Reynolds isn't muted, but I don't think it's coming from him.
That's me, Judge. I'll go ahead and mute.
My AC unit. Sorry about that. It's right in the middle. 1 second.
If you could mute Mr. Bishop, thank you. Next on the list is Rachel Crook. We're on the record in 2025 TR 116, State of Kansas versus Rachel M. Crook. Jared Regier for the state. Rachel Crook, are you present? Rachel Crook. Rachel Crook was going to look into version, but I'm not seeing that it's been filed.
That would appear to be the state's information, Your Honor. I am showing that a diversion application was received and approved by my office back in April. However, it would appear we are now past the due date of that same diversion agreement based off of my notes.
Does the state have recommendations due to the defendant's failure to appear today?
Your Honor, it would appear that when the matter first came before the court back in April, the court declined to issue orders concerning booking and bond. The state does recognize the level of the charge currently before the court in this matter. For those reasons, the state has recommended a bench warrant, $500 cash or surety.
The order of the court is a bench warrant, bond set at $500 cash or professional surety. If there's nothing further, we'll be in recess on Crook. And we'll now be on the record in Dahl, case number 2024 TR 3097, State of Kansas versus Liesl Renee Dahl. Jared Regier for the state. Lisa Dahl, are you present? Defendant fails to appear. The last time the defendant was here, she said she was applying for diversion on the one count of registration. But I do not see that diversion has been filed. So recommendations, Mr. Regier, at this time.
Your Honor, this is another case where it would appear that the court did not issue orders concerning booking and bond at the original hearing. I am showing that a diversion application was received and approved by my office. However, the state is not aware of any diversion agreements have been filed with the court in this matter, and it would appear that we are now past the diversion agreement due date based off my notes, and I am showing that such diversion application was circulated by my office over almost 3 months ago. For that reason, the state has recommended a bench warrant 500 cash or surety.
The order of the court is a bench warrant and bond is set at $500, cash or professional surety. Being in recess on Dahl, we will now take up Aaron, 2025 TR 534, State of Kansas versus Kimberly Marie Aaron. Jared Regier for the state. Kimberly Aaron, are you present?
I am.
Thank you, Miss Aaron. You are charged with that one count of driving with an unlawful registration or tag. And as you've heard me say, it's up to $2,500 in fine and 30 days to 6 months with probation and option. But you've also heard several times what has happened in cases of this nature. Let's see, Miss Aaron. I wanted to look and see. Looks like your record that I can see looks pretty good. I don't have your certified driving record, and I don't have any out-of-state records, but are you interested in diversion, or do you want to enter a plea today?
I am interested in diversion. However, the other two people that failed to meet diversion makes me a little scared that I'm not going to. But that is my preference.
Well, it's certainly up to you if you do it. And I will set this over to Wednesday. What day, Destiny?
September 17th, Your Honor.
You must be back here September 17th at 9 a.m. unless you're diverted. And if you get diverted, the county attorney will tell you whether or not you need to reappear.
Okay.
But as you've probably seen, it's not a good idea to fail to come back.
Absolutely.
All right. I'm not going to make you get a bond because today, because it's not an A or B misdemeanor. But I am ordering that I'm entering a not guilty plea and ordering that you come back September 17th at 9 a.m. unless diverted. Anything further, Miss Aaron?
No, thank you so much.
You're welcome. Mr. Regier, anything further?
No, Your Honor.
All right, then you are excused, Miss Aaron.
Thank you.
You're welcome. We'll now be on the record in Patterson, 2023 TR 3431, State of Kansas versus Audrey Nicole Patterson. Jared Regier for the state. Audrey Nicole Patterson, are you here? I know we had an alias summons go out. I'm not sure the status of service. We can take a look at that.
Your Honor, if I may, to make short work of this.
Go ahead, please.
Your Honor, I am showing a return on the alias summons was filed with the court on April 8th, 2025. That same return would appear to include both an affidavit of service and an attached document indicating, quote, your item was delivered to an individual at the address on March 29th, 2025.
It does sound like valid residential service. We will issue a bench warrant. Recommendation on bond 500, Mr. Regier.
Your Honor, this is a case where pursuant to the ticket, there appears to be one alleged count currently before the court, a violation of case 8142. The state in this matter is recommending a $1,000 cash or surety bench warrant, Your Honor. Based off of the ticket, it would appear that the ticket appears to refer to a particular address well outside the state of Kansas. And it would appear the alias summons does refer to a similar address also outside the state of Kansas. So that is the basis of the state's request.
You're requesting cash or surety?
That is the state's request, Your Honor.
All right, that will be the order of the court. We'll be in recess on Patterson and now be on the record in Reynoldson. On the record in 2025, TR 512, State of Kansas versus Jake Daniel Reynoldson. Jared Regier for the state. Mr. Reynoldson appears in person and pro se. Mr. Reynoldson, can you hear me okay?
Yes, I can. Can you hear me?
I can hear you very well. Sir, you're charged with that one count of registration. Have you heard me go over that multiple times this morning with others?
Yes, I have.
Okay, so are you wanting to apply for diversion or enter a plea?
If I get it diverted, does that mean it won't be on my record?
That is what that means.
Okay. Yeah, I would like to do that.
Okay, I'll make a note that you want to apply for diversion, and I will set your next court date according to what Destiny gives us. Is it September 8th, Destiny?
September 17th, Your Honor.
You'll need to be back here September 17th at 9 a.m. unless you get it diverted and the county attorney tells you not to. But there is a fee to apply. There is a fee to accept, and you have to somewhere in there pay your fines and costs. So I just don't want you to be caught off guard on that.
Okay.
Go online. Nobody's asked me about how to do that as far as going online.
That was going to be my next question.
That's concerning that no one thought to ask that. You go to BUCOKS.com. That's Butler County, Kansas abbreviated .com. BUCOKS.com. Look for diversion, click on that, and it'll walk you through what you have to do to get diversion. You can apply online. If you have any questions, you can call the county attorney at 316-321-6999.
316-321-6999.
Yes,
All righty. Thank you.
you are welcome. Anything further, Mr. Regier, on this matter?
No, Your Honor.
Then Mr. Reynoldson is excused at this time.
Thank you.
You're welcome. Will now be on the record in Smith, 2025 TR 521, State of Kansas versus Christopher LaShawn Smith. Jared Regier appearing for the state. Christopher LaShawn Smith, are you here? Christopher LaShawn Smith fails to appear after having been given a citation and notice to appear. The officer served him with that citation and notice to appear for June 18th, 2025 at 9 a.m. The defendant, according to the officer's note, signed personally and fails to appear. So recommendations from the state, Mr. Regier?
Your Honor, although the state does acknowledge the level of the charge currently before the court, the ticket also appears to refer to a particular address outside the state of Kansas. State is recommending a 1,000 cash or surety bench warrant.
Bench warrant is issued. Bond is set at $1,000 cash for professional surety required.
Thank you, Your Honor.
You're welcome. If there's nothing further, we'll be in recess on Smith. Leah Stein. We are on the record in 24 TR 604, State of Kansas versus Leah Nicole Stein. Jared Regier appearing for the state. Leah Stein, are you here?
Yes, I'm here.
Miss Stein, you have had trouble getting here for your first appearance, it looks like.
Yes. I did, I will say back in January, no, not January, February, March. At the beginning of this year, I did come and turn myself in to serve for not coming to my first appearance because I thought I only had a ticket and not a court date. I mean, I'm not using that as an excuse, but once I found out that I had missed a court date, that's when I came and turned myself in.
All right, and did you post a bond at that time? Yes, you did.
Yeah.
Looks like you posted a $500 bond on February 28th, 2025, the second chance bail bond.
Yep.
And you're hearing on that now. Well, you are looking at one count of registration violation. That's the one we've been talking about all morning.
That was it's my tags, correct?
Well, yeah, let me read you that.
And Your Honor, for the court's edification, I am showing an amended information was filed with this case on May 14th of 2024.
Well, Ms. Stein, there is a document entitled Amended Information, amending the ticket to read on or about the 27th day of February, 2024 in Butler County, Kansas. Leah Nicole Stein did then and there unlawfully operate or attempt to operate a motor vehicle, to wit, 2015 Toyota, upon a highway of the state, to wit, I-35, 63.8 North Mile Marker, while such vehicle was not registered in violation of KSA 8-142, failure to register vehicle, an unclassified non-person misdemeanor. When you register, that is when you get your tag. So does that help answer your questions?
I think so. So it was because I know my tags had just expired, I believe, and I don't remember how many days it was, but I mean, I got it taken care of. But that I just wanted to make sure that that's what it was.
That's what we're talking about, is you hadn't registered it for the current year. You hadn't tagged it for the current year.
Okay. Yeah.
Now, how do you want to proceed? Are you going to hire an attorney, apply for court appointed, or represent yourself?
I'll just represent myself.
You understand you do have the right to hire an attorney or apply for court appointed?
Yeah.
Is anyone making you give up your right to an attorney today?
No.
All right. I don't have a written form to hand you across the Zoom camera, but I will have the record note that you have knowingly and voluntarily waived your right to counsel.
Okay.
And then I see you have a number of things going on.
With
have had.
Yeah, I've got those. I'm actually on diversion right now for that. I've got that taken care of.
All right. How do you want to proceed on the charge today? You can plead not guilty, set it for trial, or you can plead guilty, admitting it, and be sentenced, or you can plead no contest, neither admitting or denying, but you'd still be found guilty and proceed with sentencing.
I'll plead no contest.
By pleading no contest, you don't want to admit the charge, but you don't want to deny it and take it to trial?
Right.
Is anyone making you proceed in this manner?
No, ma'am.
You're voluntarily entering the no contest plea?
Yes.
Mr. Regier, have you a factual basis?
One moment, Your Honor.
I do have a question also. I don't know. Am I allowed to speak right now?
Yes. go ahead.
It's just about my driver's license because I called the district attorney, I believe, for Butler County, and they told me if I paid like $122 fine that or reinstatement fee that I would be able to have my driver's license back. I just wanted to verify that or know if that was accurate.
Well, what that $122, Ms. Stein, where that comes from is that you didn't take care of this in time. So the Kansas Department of Revenue suspended you. And to get your license reinstated, you do have to pay a reinstatement fee of $122, independent of what happens on the charge today.
Okay, and that's through you guys is who?
If the 122 is through the state, but Destiny, the clerk, can accept that,
We can, Your Honor, yeah.
but it's the Department of Revenue that has suspended you and has assessed the money. But you can go through the state or through the clerk to pay that.
Okay.
All right. So, Mr. Regier, you have a factual basis,
Yes, Your Honor, if I may.
please?
Your Honor, this is a case where were this case proceed to trial, state's evidence would show that a stop occurred on February 27th, 2024, involving a 2015 Toyota. The location of the stop pursuant to the ticket and the amended information appears to be I-35 at milepost 63.8 north. State's understanding is that is within Butler County boundaries between Augusta and Towanda city limits. Additionally, besides citing the defendant for a violation of KSA 8142, the state's evidence show that this is a case where involving a temporary tag, the officer noted a license year of that same tag of 2023, which would appear to be prior to the February 27, 2024 stop.
I find that the defendant is knowingly and voluntarily entered her plea of no contest, and the state has provided a factual basis to support it. Therefore, I find the defendant guilty of driving with lack of registration, that is unlawful registration or tag. And Mr. Regier, recommendations, if any, for sentencing?
$50 fine, court costs, 30 days suspended, 6 months on reporting probation, Your Honor.
Anything you want to say, Ms. Stein, before I pronounce her sentence?
Just with that 30 days suspended, is that me or is that my driver's license suspended? So I'll have to wait 30 days or what does that mean?
Okay, well, other than the question, do you have anything you want to say? I will answer that. Do you have any?
No, that's all I have to say.
All right, I am going to follow the recommendations and impose a $50 fine and 108 court costs. I'm also going to order that you pay the $122 reinstatement fee.
And Your Honor, forgive my interjection. Does the court wish the journal entry to reflect the reinstatement fees?
Yes.
Thank you, Your Honor.
You're welcome. That looks like it's about $280. Can you pay that within the next 30 days, or do you need some more time?
Yeah, I can pay that within the next 30 days. It's about 280.
That's what I'm just roughly looking at.
And is
Oh.
there any way that I can pay that I live 2 hours away, so I didn't know.
You can pay that online. In fact, if you call the clerk's office, The clerk can tell you the different ways to pay, including the website for online. Do you have a pen to write down their number?
Yes, give me 1 minute. Actually, put it on my iPad.
Everyone always come to court with a pen or paper, pen or pencil and paper, always, always.
Okay, I am ready.
It's area code 316-322-4370.
Okay, and I just call them about paying those
Yes.
fees off.
Yes. And so I'm ordering that you pay that within 30 days. Now your sentence is 30 days in the county jail, but it is suspended. You won't have to serve it so long as you successfully complete a 6-month non-reporting probation. Non-reporting means you do not have to see a probation officer, but you do have requirements. The first one is to pay the total amount due within 30 days. The second is to violate no laws during the next 6 months.
Okay.
So if you get that paid and you don't violate any laws, the case will close in 6 months. Do you have any questions about any of this?
No, ma'am.
Mr. Aguirre, anything further?
No, Your Honor.
Then, Ms. Stein, you are excused at this time.
Thank you.
You're welcome. We're going to take up Testerman 2024 TR 3412 on the record in state of Kansas versus Dalton Ray Testerman. Jared Regier for the state, Dalton Testerman present. Mr. Regier, it looks like we may have no service.
One moment, Your Honor. Your Honor, with all due respect, this is a case where it would appear the ticket includes a notice to appear date of April 2nd, 2025 at 9 a.m. Based off my notes from that hearing, the court made a finding that the defendant failed to appear but continued the matter to today's date and time with instructions by my office to prepare a notice of hearing. I am showing a notice of hearing was filed with the court by my office, and there does appear to be an affidavit of certified mail at the same address on the ticket with an attached document with a notation stating, quote, return to sender unclaimed, unable to forward. So it would appear, if the court will pardon the conjecture, that this is a defendant who has had 2 opportunities at notice in this matter.
Do you find the defendant was given notice, but was legally attempted, notice was legally attempted. I'm going to issue a bench warrant at this time, recommendation for bond. He has a lot of charges here.
Your Honor, this is a case where it would appear an amended information was filed by my office on March 27 of 2025, dismissing count 1 while retaining counts 2, 3, 4, and 5. It would appear, however, that at least 2 of those charges are infractions, so the court may or may not consider that relevant. Although count 3 and count 4 appear to be an unclassified and class B misdemeanor respectively. In light of that and the multiple attempts at services recognized by the court on the record today, it is recommending a bench warrant, $2,500 cash surety.
Vince Dandy, could you mute, please?
Yes, I'm here, Honor.
Will you mute your
I
I
am.
need to turn off your volume for a minute. We're in the middle of someone else's hearing, and you're making a sound that's distracting and interfering. All right, so I am going to follow the state's recommendation due to Mr. Testerman's failure to appear and issue a bench warrant bond set at $2,500, cash or professional surety required. Will be on the record in Trujillo, on the record in 25 TR 1033, State of Kansas versus Anelio Trujillo. Jared Regier for the state. Is the defendant present? Trujillo, Trujillo, maybe it's Trujillo. In any event, the defendant is on bond for driving while suspended, driving without insurance, driving without a tag. No, he's supposed to be on bond. I'm not seeing a copy of it in the file. Mr. Regier?
Your Honor, I do appear to have a cash bond in my file on this case. It appears to refer to today's date and time, June 18th, 2025 at 9 a.m. in the amount of $1,500. The bond itself would appear to suggest that that on the address line for the defendant appears to indicate, quote, homeless. Additionally, this does appear to be a defendant who was recently sentenced on an unrelated matter by this court, 24 CR 466. It would appear that in that matter on February 3rd of 2025, the defendant appeared in custody with court-appointed counsel attorney Darren Patterson, and the information in the current case actually before the court would appear to be alleged in the current state of February 27th, 2025, approximately 3 weeks after the sentencing date in that unrelated 24 CR case.
Finding the defendant fails to appear, I will issue a bond forfeiture bench warrant, recommendations for bond.
At the very least, Your Honor, the state would be recommending the court double the amount to 3,000 cash or surety. However, in light of the working parts of this case and the defendant's prior history before this court, if the court considers it relevant, the state would not be opposed to a higher bond up to and including a no bond hold.
We'll set the bond at 5,000 cash or surety.
Thank you, Your Honor.
Welcome. Being in recess on Trujillo, we'll now take up Sparks. On the record in 2024 TR 2897, State of Kansas versus Kathleen Michelle Sparks. Jared Regier for the state. Is Kathleen Sparks present? Kathleen Sparks. Fails to appear on summons. It looks like it was served. Mr. Regier, recommendations?
Your Honor, the return in my file would appear to suggest residential tack down over 3 months ago. It would also appear that pursuant to the amended information, this is a case involving at least one unclassified misdemeanor and one infraction. State is recommending at the very least a bench warrant 500 cash or surety.
Bench warrant will issue. Bond set at 500 cash or surety. Be in recess on Sparks at this time. We will be on the record in Shaw 2025 TR 665, State of Kansas versus Michael Lee Shaw. Jared Regier for the state. Michael Shaw, are you here? I believe that a summons was unsuccessful in service. I believe an alias was unsuccessful. And have we taken any other steps to get Mr. Shaw at the court, Mr. Regier?
Your Honor, in light of the apparent difficulties as highlighted by the court already, I am showing that a certain request was filed by my office with the court on June 13th of this year. Based off my notes, I do not know the status of the same.
The status shows the action was granted. We will maintain that status.
In light of that, Your Honor, it would appear appropriate the state would respectfully submit to take this matter off the docket pending further proceedings.
Will be done. Thank you.
Thank you, Your Honor.
We will now be on the record in 25 TR 454, State of Kansas versus Gustavo Alonso Rodriguez Gonzalez. County Attorney Jared Regier for the state. Mr. Gonzalez, are you here? No Gonzalez. Mr. Gonzalez fails to appear. I guess it's Rodriguez Gonzalez. Recommendations, Mr.
Diversion agreement circulated approximately 3 weeks ago. However, it would appear the diversion agreement due date has already passed. And I'm also showing that this particular hearing on June 18, 2025 was specifically set by the defendant based off my notes in my file.
The court finding that the defendant fails to appear for a speeding citation will issue a clerk's letter.
Thank you, Your Honor.
You're welcome. We'll now be on the record in Majors 2025 TR 490, State of Kansas versus Lauren Michael Majors. Jared Regier for the state. I'm looking for Lauren Majors, who fails to appear. Recommendations. He was going to apply. No, strike that.
Your Honor, this appears to be the first setting before the court on this matter. I am showing a notice to appear date on the ticket for today's date and time, August 16th of 2025. This does appear to be a case where an amended information was filed with the court on June 11th of 2025, amending count 1 to KSA 8291, driving in violation of restrictions and classified non-person misdemeanor. Your Honor, if I may have 30 seconds to review the necessary statutory provisions, at which time I will be in a position to make appropriate recommendations.
The request for 30 seconds is granted.
Thank you, Your Honor.
You're welcome.
Your Honor, if I may.
Go ahead.
Your Honor, pursuant to the statutory provisions of KSA 8291, although it is the state's information that count 1 is charged as an unclassified misdemeanor, the statutory provisions of KSA 8291 do not appear to address the imposition of any underlying sentences or outright jail sentences, rather a fine and a prospective suspension of a convicted person's driving privileges. So I'm not sure if the court wants to issue a clerk's letter of suspension.
Mr. Dandy, you have been assigned Attorney Darren Patterson on this case, but you have had a failure to appear. consequently a bench warrant.
Right, I
With-
got that care
It
of.
looks like you did post the bond on that, March 21st.
I just didn't have the right getting up there. Like right now, I don't have one.
I'm sorry, say that again.
I said I didn't have no right getting up there.
Well, you always could have appeared by Zoom as you're doing today.
Yeah, I apologize. I didn't know when I was when the court date was. I lost my paper.
Well, at this time, we're gonna have to put this on Mr. Patterson's docket on a Monday. So when is the next date that Mr. Patterson has?
September 8th, Your Honor.
Because you failed to appear, this is gonna end up September, you said 8th?
That's correct, Your Honor, the 8th.
All
Okay,
right,
so
you have to be back here September 8th.
okay.
Do we have court September 8th? Or do we have a pro tem judge?
I think we have a pro temp on that date, Your Honor. I can check and make sure.
Would you please?
It looks like we just have regular court.
Oh, okay. September 8th. I'm hesitating because I thought I was going to be gone the last week of August and the first of September.
The last week of August, we're closed for court on that day, but then September 1st is a holiday.
We're on a Monday. I was thinking this was a Wednesday docket, but we're putting him on a Monday. Okay, I'm with you now. All right, so you have to be back here, Mr. Dandy, as a condition of your bond, September 8th. That's Monday, September 8th at 8 a.m.
Okay.
No.
Is there a way I can possibly get on Zoom because I have a hard time getting up there? That's like a 3-hour drive where I'm at.
Sir, I think you've been told several times, including the date you didn't come to court, that you could appear by Zoom.
Okay. So I still be available to Zoom then?
And Your Honor, may I interject very briefly?
Go ahead.
Your Honor, while of course per my custom, it is always the state's preference to proceed in the presence of counsel for the defense, based off my notes from the first hearing in this case, it would appear that the defendant appeared in an audio-only fashion on December 11th of 2024, and the court did enter specific orders that the defendant shall either appear in person or be able to appear by Zoom both audibly and visually. So I'm not sure what the court wants to do with that.
What date was that, Mr. Regier?
Based off my notes, Your Honor, from a scheduled hearing, December 11th of 2024.
And then March 3rd, you had a hearing, Mr. Dandy, that you failed to appear for. And Mr. Patterson said he'd had no contact with you and that you'd failed to be booked and printed as I'd ordered. So you failed to follow my order. I show that you failed initially to go out and get booked when or that you failed to go out and get booked and printed when I told you to. Violation of court order. That you failed to go over and contact Mr. Patterson like I told you to. Second court order violation. That you failed to come to court March 3rd as told to do. Third court order violation. June 17th, you talked to the clerk and you said you had no car, no driver's license, no one to bring you to the courthouse. You were asked if you could appear by Zoom and you were told you could. You were given the Zoom codes over the phone and was told the correct time for court. And you were told that you would need a strong Wi-Fi connection and video and audible. You repeated the codes back for confirmation. Then June 18th, today, I understand that you had lost your codes and you were given them again.
Yeah, it came out of my pocket somehow. I had it written down on the sticky note, and then it slipped out of my pocket. And then that's when I called up there this morning before I got on here, and I said, "Hey, is there a way I can get the code again? Because I dropped it somewhere and I didn't know where it went." So
Well, that was between yesterday's call to the clerk and today's call to the clerk. You'd lost them out of your pocket.
not this one, no. I did yesterday. I was over at a friend's house, and apparently I was looking for it in my pocket, and I guess it slipped out of my pocket, and I didn't realize that until when I got home.
Did you ever get your picture and prints taken? You do that on your warrant after you failed to appear? Looks like you did. March 21st of 2025, you posted a $2,000 surety bond. March 21st, after I told you to do it, December 9th. And you only did it now because the sheriff came and got you apparently.
Yeah, I was on my way to Hutch, and he pulled me over.
Well, do you see we have a problem, Mr. Dandy?
Yeah, a little bit. Yeah,
A little bit.
yeah.
And the Wi-Fi you have today is making a lot of noise. Your system is. Are you at home?
Yes, I am, Honor.
What are you doing?
I was sitting in my chair. You probably was hearing my fan. I apologize.
So what are you doing? Going to turn off your phone or fan?
No, I just went into this other room in my kitchen.
You just wanted to change locations in the middle of your hearing? Is that what you did? You just decided to get up and change locations?
Yeah, because you were saying that you couldn't hear me and you were hearing the noises in the background, so I moved into another room.
Well, I don't know that I said I couldn't hear you. If I did, I didn't mean to. I could hear you, but there's a lot of interference, even in this room. All right, well, let's decide where we're going from here, in spite of the fact that you've violated just about every order I've made. You're charged with driving while suspended.
Yeah,
You applied for and had Mr. Patterson represent you, and I told you to contact him, and you didn't. So, is there any chance in the world you're going to follow my order today?
Yes,
I tell you to contact him again.
yes, Honor.
Do you know how to do a chat on here today?
I do not know.
Well, I need your address, your phone number to get to Mr. Patterson. And I'm not sure I can trust you to do it.
Okay. So what do you need me to do?
Well, that's what I'm deciding. I'm gonna give you one more chance to hang up when we're through with this hearing to call Mr. Patterson's office.
Okay.
If I find out you didn't, I'll probably put you in jail and have you wait there until we know that you can talk to Mr. Patterson.
Is there a way I can get his phone number and I will call him as soon as I get out of here?
There he is. Are you ready?
Yeah.
It's Darren, D-A-R-R-E-N, Patterson, P-A-T-T-E-R-S-O-N.
Okay.
I gave you this before, but I'll give it to you again. 316-322.
16. You said 316?
I did, and then 322.
three,
Two.
three.
All right, did you get the prefix 316?
Yes, I got the 316.
And
And
then,
then
okay, and then it's 322.
oh, my bad. 322. Okay.
And now the other part of it is 77
7.
and then 0, 0.
Okay. All right. You said 316 322 7700.
Yes. And
All
it's
right.
Darren Patterson. And you're gonna call him as soon as we're through here today, and you're gonna make sure that you give him all your contact information, your address, your phone number, your email, whatever he needs there.
Okay. And Honor,
Yes.
phone is clearly off right now, but I have a text now app on my phone so I can get a hold of people, but I just didn't have the money to pay my service because I clearly unemployed right now. I don't have a job right now. So that's the only way I can do it right now. So
Okay, so I'm not too familiar with text now. You're saying that you'd have to text him?
no, I can call them. It's just an app that says text now. I can call or text, but I can call.
Okay. Make sure you get a hold of him.
I will.
And I'm going to let you reappear by Zoom. What town and state do you live in?
I live in Great Bend, Kansas, 67530.
So don't give out any information over the internet.
Oh, my bad.
That's just to protect you. All right, well, that's quite a ways off, so you can appear, but make sure your internet is good where I can hear you. See you. Mr. Regier, anything further other than to continue the bond and pick a date?
Just to be clear, Your Honor, the court is continuing this matter to September 8th at 9 a.m., rather 8 a.m.
September 8th at 8, or September 8th at 8 a.m.
Thank you, Your Honor. Nothing further
Did
from
you
the
get that? Did you get that, Mr. Dandy? September 8th at 8 a.m., remember?
Yep. I will
Yeah.
put that on the calendar.
Well, write it down. Did you write it down?
Yeah, I did.
Okay, September 8th at 8 a.m. Now, I'm gonna continue the bond with the added conditions that you call Mr. Patterson and you reappear September 8th at 8 a.m. Those will be different Zoom codes and you'll be able to get those from Mr. Patterson.
Okay.
All right, there's nothing further. Anything further, Mr. Dandy?
No.
All right, then you are excused today, but you're ordered to contact Mr. Patterson.
Alrighty, I will give him a call.
All
Thank
right,
you.
thank you, sir. You're welcome. You're excused at this time. Thank you. Will now be on the record in 24 TR 3437, State of Kansas versus Nolan Grant Colvin. Jared Regier for the state, Nolan Grant Colvin. Looks like he fails to appear. He also failed to appear April 2nd. But he fell within that false information that the courthouse was closed due to a water issue.
And Your Honor, for the court certification, I am showing an affidavit of service by certified mail filed April 29th of 2025. It appears to refer to a notice of hearing that includes both today's date and time, June 18th, 2025 at 9 a.m. And there appears to be an attached document indicating that, quote, your item was delivered to an individual at the address on April 11th, 2025.
I find the defendant was given legal notice. On forfeiture, bench warrant, recommendations for bond, Mr. Review.
Your Honor, the state's information is that this court has never made issues concerning booking and bond in this case, so the state is recommending a bench warrant. State is respectfully recommending $1,500 cash or surety based off of the charges currently before the court.
That recommendation is adopted as orders of the court. Bench warrant, bond set at $1,500. Being in recess on Colvin, we'll now turn to Collins. On the record in 20, okay. On the record in 2002, TO.
Okay, thank you, Your Honor.
You're welcome. We are on the record in 25 TR 631, State of Kansas versus Brian Altman. Jared Regier for the state. The defendant appears in person and pro se. This matter comes on for hearing at the request of the defendant on the charge of violating the basic speed rule. That is driving too fast for conditions. This is an infraction. Mr. Altman, are you wanting to set this for trial?
Yes, Your Honor.
All right. When's our next trial date for him?
It'll be our last one on August 13th, Your Honor.
All right. You must be back here August 13 at 1:30, ready to go to trial, Mr. Altman.
Thank you, Your Honor.
You're
Nope.
welcome. Nothing further. We'll be in recess on Altman. Now I show that concludes everyone on our list, but I have a couple of individuals, at least one of which has been here quite a while. The one named Kathy, what's your full name?
It's Kathleen Sparks.
All right, I called your case and you didn't answer when I called it. So a bench warrant, bond forfeiture or a bench warrant was issued.
Yes, ma'am. I apologize.
Okay, so you came in after that?
Yes, ma'am. I'm at work and I couldn't get logged on quick enough.
All right, we'll go back on the record in 2024 TR 2897, State of Kansas versus Kathleen Michelle Sparks. Jared Regier for the state. Defendant appears in person. Miss Sparks, count 1 was dismissed on an amended information. Count 2 alleges that you were driving with a tag not assigned to a vehicle. And count 3 looks like speeding.
No.
Let me look that up.
It was for weather conditions.
Speed greater than reasonable for conditions. It's a form of speeding.
Yes. I'd like to contest that because it was not raining at the time. And I have a new keep it in your lane thing on your car. And I have a feeling it was just the line was wet. I have about 480 horsepower going to my rear tires. I think when it tried to move me back over into my lane, it put me into a tailspin and I went into a 360 and just spun off into a field. I
Well,
definitely was.
We'll take that up at trial. When's your next trial, Destiny?
Your Honor, that date is going to be August 20th.
August 20th at 1:30. Now, bring any evidence to prove what you're saying. Documents have to include the preparer of those documents generally. All right, so be back here for trial, August 20th at 1:30, and we'll take up both charges at that time.
What kind of proof can I bring? I mean, I don't understand.
I can't give you legal advice. I'm not your attorney. You can talk to an attorney about that. You can hire an attorney if you wanted to. But your evidence would be up to you to decide.
Okay, I can't prove that it wasn't raining at that time.
Well, I can't be your attorney, so
Can I talk to the prosecutor?
Well, you can call the prosecutor at another date and time. That'll be up to him if he wants to talk to you, but he's not going to be your attorney either. He's the one prosecuting you.
Okay.
All right, well, we'll be in recess at this time. You may go.
Your Honor.
Thank you.
Yes, I'm withdrawing the bench warrant, the bond forfeiture. Mr. Regier, anything further?
No, Your Honor. Thank you.
You're welcome. And then.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?